Right, okay, stop. Thank you for staying. Let's get underway with the here, Julie.
Ia uru mai, aha ora, aha kaha, aha mai. Ia uru mai, aha ora, aha kaha, aha mai. Ki runga ki raro, ki roto ki waho.
Yes, well, welcome to it's a continuation of our hearing 4 that myself and Commissioner Littlejohn heard very early on in our process, so late last year. So welcome everybody. My name is Stephen Dayton. I'm the chair of the hearing panel. Beside me is Commissioner Littlejohn. I'm a member of our panel, and we are considering the noise matters in terms of our briefly hearings that we're covering together. So just by way of introduction, the panel has been asked by the Commonwealth District Council to hear and make recommendations to them on all associated with the proposed district plan. Before we started our process in June last year, I know we've got 2 more hearings after this one, finishing up towards the end of August. I can see Edward sitting there over there. She's finished all of her work really into the council side, which is a huge milestone. I want to acknowledge you and the team, that massive amount of work that you've done, waiting obviously for recommendations to come through. So to acknowledge you. The other thing to note is that this hearing is recorded. All our hearings are recorded on Zoom, which provide a record for oral evidence and also questioning of experts. So just be mindful of that. Just in terms of potential conflicts of interest, panel issued a minute right at the start of the hearing about how we were managing conflicts of interest. We've had no queries or concerns about that throughout the whole hearing process, but need to pause and see if there's any issues that parties might see with us hearing these matters. Okay, no issues. Thank you very much. We will take some appearances start of the hearing as we do. So, introduce Kit already. Christine.
Good morning, everyone. I'm Christine Brummel, and I'm part of the administration team.
Hamish Wesley, reporting officer with a noise topic.
Thank you, Hamish.
Keith Holswick, your hearing topic.
Morning, everyone. Sarah Edwards, District.
I'm Douglas Allen. I'm councillor. Michael Campbell, planner.
Good Singh, team leader for Kindle. John Stiles, advising Kindle on noises vibration.
John, welcome.
And Brendan, manager.
Yes, thank you. Thank you for attending again, Kindle routine. A lot of work needed into that as well, so welcome back. So we'll just go to the screen. Nigel, I can just see you there first for me.
Yes, Nigel Lloyd, acoustic consultant. I've been advising council.
Thank you, Nigel. Stephen Childs.
Yep. Good morning, everyone. Stephen Childs, acoustic engineer engaged by Waka Kotahi and KiwiRail.
Thank you. You're coming in from Christchurch, Stephen. Is that right?
Yep, that's correct. Nice and sunny here today.
Yeah, it's a lovely day here too. So great. So Lauren, you're next on my list. Yeah, Alan. Oh, yeah, here's Lauren. Yeah.
Kia ora, good morning. Apologies, just having some Zoom difficulties. Lauren Rapley, we are acting for KiwiRail Holdings Limited. I'll be appearing this afternoon with Alison Arthur Young and our team.
Yes, we've got you at 3 o'clock, I think. Lauren, it's penciled in.
Yes, that's
So-
correct.
So thank you. Right, Christina.
Hi, Christina Sheard. So I'm just having a bit of a problem with my video. Oh, there we go.
Oh, there you go. Yeah.
Yeah, Christina Sheard appearing for Waka Kotahi.
Okay, Christina, where are you coming to us from?
I'm coming to you from Auckland. I'm actually a bit
Okay.
unwell today, so excuse me if I don't sound 100%. I actually sound and probably look worse than I feel. Got a bit of a touch of the flu this morning. So yeah,
Oh,
at
yeah,
home.
I would just take it easy. Okay, thank you.
Thank you.
And Alan Catchpole is the last one I can see on the screen. So welcome, Alan.
Yes, good morning, sir. I'm just here sitting in for Waka Kotahi.
Okay, thank you. Good to see you or hear you again, Alan. Thank you. All right, so we've got a day set aside to deal with this. So just to record, I think you've already been advised, we have read all of the evidence. Summary evidence, except for, I know, Keith, you'll get a little statement you might want to read out, but we're ready to go pretty much straight into questions. But we are interested in hearing from you, Hamish. There's been a flurry of new evidence since you've presented your 42A addendum report. So yeah, just take us through where you're up to in your mind. Thank you.
We have prepared a presentation.
Yes,
the same
right.
way, but
Yes.
all hearings. So
Yes,
it starts off.
just go through it. It'll get us focused. Thank you.
So the contents is the same material what presented at previous hearing, or the same type of material. So I'll just step you through that. Slide, Christine. The first, just to remind us all what the locations are, the areas we're talking about. The state highway network and the railway corridor. So this is the whole district. So from the south, just north of Stratford, railway line and the highway pretty much parallel to each other, and then you're off at Inglewood, with the railway line branching out towards between Waitara and Bellblock, and then extending through to the port to the west. And then, the state highway 45 and 3 go the western district all the way up.
Hamish, I'll ask this question early, but the rail line that's been retired in 2004, Stratford to Karamanui.
So yeah, it's not shown on that. Not shown on that map.
Is there any part of that within your district?
I don't think so. From
No.
when I looked at the map.
No, I was interested in that because I followed it. Yes, I could, you know, I know that rail line. Yes, so it's not germane to what we're talking about.
Thank you, Ray, mate. You should correct us if we're misunderstanding.
Thank you.
So next map is literally a Zoom conversion. This is a reference if we need it throughout today. Next slide. In terms of the approach and the operative plan, the only noise insulation requirement regarding state highways or railway lines relates to area Q out of Bellblock, and that was when that area was rezoned for development. 8 metre insulation requirement was that plan change. But there's no other requirements for noise insulation on the state highway or the railway line. In terms of review,
And it's just on that area Q, was that inserted following submission to 80 metres?
I understand it was in the original notified version. Then, in response to feedback and reviewing the plan, QRail and Waka Kotahi both raised review sensitivity and the issue of noise for the state highway and the railway line, and that was the basis for its inclusion in the proposed district plan. In terms of what was in the proposed plan as notified, so noise insulation requirements applying to the state highway and the full extent of the railway corridor, but only within certain zones. So for the railway corridor, the setback requirement applied within 60 metres of the rail corridor within 3 zones: the rural, production and lifestyle zone and the future urban zone. And for the state highway, that was an 80-metre area and applied to the same 3 zones plus also residential. In terms of the requirements, the same applies to both railway corridor and state highway, so it's a requirement for all noise rooms for noise sensitive activity to achieve a level, and the certificates required to demonstrate compliance time of consent. And that is also required to make sure the ventilation system provider to achieve that standard, those must be closed. And then if it's non-compliant with that standard, it's restricted discretionary activity. In terms of the submissions, well, across that, in terms of the evidence, there were original submissions from QRail and Waka Kotahi seeking standards apply for both noise and vibration in all zones, based on slightly larger setbacks or larger areas than what's in the proposed plan as applied. Kaingaora further submission on KiwiRail request, and they also submitted an opposition to Waka Kotahi along with the and Te Atiawa. In terms of what was raised in submissions and the evidence as to the why, mentioned today. Firstly, that the noise and vibration can cause community and health effects from the railway corridor and the state highways, and the evidence from Waka Kotahi and QRail that there's potential for reverse sensitivity issues, and there's debate and the evidence around what reverse sensitivity actually is. And the Kaingaora evidence is questioning the adequacy of the information, or is there certain, if there's insufficient information, should fact or not fact. In our evaluation, based on what was in evidence, original evidence that was received, we recommended retaining the objective and policy framework with some kind of amendments to make policies more specific to the requirements for installation. Recommended retaining the 80-metre distance for the state highways within the zones as notified. Recommended deleting the requirement for the rail corridor based on insufficient information or the information that would exist indicated that low train movements, therefore low levels of noise, and that in terms of vibration for both state highways and state highways, sorry, for the rail corridor and state highways, we recommended not adding a policy or vibration view that there wasn't sufficient evidence of an issue for that. In terms of where we're at now, and that is in contention, and from what we've read in the legal submissions and the evidence that's been received, but the nature and magnitude of this with issue and vibration issue in rather line the state highway. There is, in our view, some uncertainty around this magnitude of that problem. Therefore, what action should be taken, or action should be taken based on that level of information. And then depending on what the conclusion is on those above 2 meters, the scale and magnitude of the problem or information need to then determine what the distances are that should apply and what zones they should apply to. But at this point, having read the latest evidence, haven't changed our position in terms of our view, but keen to hear through questioning some of the answers to questions next, particularly around noise environment. Got some questions around the assumptions, and appreciate it's only very recently available, so then that better, as well as the QRail evidence around future planning that could that and how that will influence the noise environment. That's an overview to get us started.
Some questions? Yeah, just a couple of starters, because it's going to be an interesting day, really. The first one, your updated assessment, you ultimately came down on the side of a metric-based setback as opposed to a model one, principally because there wasn't a model one available. assuming we sort of pull the hood off that and come to a view that that is the most appropriate approach. Does your position remain the same, that a metric's just a much easier tool to use?
Yes, and but we're interested to understand those assumptions that the model is based on, and if they changed over time. So, for example, just reading the information, Lloyd might maybe elaborate on this. It's based on buildings as they exist today. If those buildings change, that influences the
Yeah, that is obviously a critical.
So there's some yeah, that's just probably one that matters to understand that can you what and script might be variable to a model. But if the modeling demonstrates that that's fairly fine grained and that change to it don't have a material effect on location. So there's some merit in the model approach. But keen to understand that modeling a bit more. Right,
The other one that, the other issue that I think spend a bit of time talking about today is this differentiation between the proposal for controls for state highways where the set traffic limit is 70 kilometres an hour or faster, versus it's less than 70 kilometres an hour. We don't worry about it. And I think that the evidence is a little bit grey in my mind at the moment about whether the less than 70 kilometres an hour takes us absolutely below the threshold that I think all the acoustic experts are saying we ought to start to have a bit of a concern about. If indeed there is still that potential in the below 70 kilometre environment for there to be adverse effects, what would be the reason for us to not put in place a control in the face of that evidence?
It's the magnitude of the effect. That's what reading noise.
How large an area it will apply to.
Exactly.
So that is us in the engine room of section 32 coming to a view that, notwithstanding the identified potential effect, the cost of regulating to manage it outweighs the benefit to be gained in doing so.
And that's similar to the rail corridor.
Yeah.
In terms of, is the noise at such a level at the moment, such a magnitude at the moment, that's the cost of requiring a certificate, which might say, well, actually noise at the moment you can buy it already, you don't need to do anything. That cost of requiring that justify that potential benefit to the community and health.
Thanks for that. Again, that's probably something we'll talk a bit more about today. I guess the third start of 10 for me is really around this notion of, I guess, the burden of proof on an infrastructure operator to establish what the future environment is going to look like based on stuff that they've got no idea is ever going to happen. And I guess I wanted to just test you on that as to whether that's actually critical when the infrastructure itself has been recognised as regionally significant. But doesn't that sort of put the burden of proof of future level of use to one side and actually warrant an approach which is really just about trying to come up with the best planning outcome, assuming that you've got this important but potentially noisy thing snaking its way through your city?
Yes, and I think the legal submissions Heavy Rail highlight that's that point they're making, and which I accept. It's good planning to exactly what you just outlined. But it's if the level of noise that demonstrates that you'd be meeting the internal installation noise level as it stands, you're effectively imposing the cost for no benefit. But recognising that could change it. that's that weighing up.
Mm.
It's a potential benefit, really, isn't it? An actual cost for a potential benefit, and whether that balance is struck right. Yeah.
Mm.
Okay, thank you.
Thank you. Just bouncing off those questions, Nigel, if you can perhaps come on the screen. Yes, can you hear me okay there, Nigel?
Yes.
We're having a bit of trouble with this room. Okay, thank
Yeah,
you.
I did miss Hamish there. A few of his questions, he was quite difficult to understand. He kept cutting out. So hopefully I say the same thing as he does.
Yes.
So
So
there's a good test then, isn't it?
we have been having a few issues with acoustics in this room recently. This has been a new arrangement. So just as a request for anyone online, if you can't hear stuff, please just pop up and tell us. We won't take offence. We'll just need to raise our voices and look up rather than look down, which is one of my bad habits. But so Nigel, we've seen the new modelling evidence coming on Friday from Stephen. Just to kick us off, what's top of mind for you with that new modelling evidence and how we might or might not apply it to the New Plymouth situation?
So I think the modelling evidence, well, it will be good to hear from Dr. Charles first, really, as far as, I did talk to Dr. Charles. I'm not sure how much of that was without prejudice or not, but before that modelling came through, basically it just sets, he's worked on the 54 dBA LAQ contours to try and show the extent of where impacts of noise are likely to be. And of course, there's no argument that in noise levels less than 70 dBA, there may be locations where the noise levels are greater than would be desirable. And that modelling demonstrates that and clearly shows that in the higher noise levels.
Okay. All right, well, we'll hear from Stephen a bit later on, obviously. So thanks for that. Hamish, I do have two quick questions for you. The first one is in relation to, I suppose, similarities or not between the high voltage transmission line setbacks and this issue in your mind. They've used a standard width corridor, but I presume without modelling. So what's in terms of consistency of both the legal tests and planning functions? What's your view on that?
Firstly, I'd better declare that Optimiscal, who I work for, does a lot of work for Transpower New Zealand around that issue.
That has been cleared, so
yeah,
yes.
so I'm not directly involved myself, but I need to make that known to the Commissioner. In terms of the similarities in the sense of it's a reverse sensitivity type issue, I understand that so an access to national grid assets, and that basis for the corridor widths, it's not a noise issue. It's
Health and safety
yes,
and access.
and access. So in terms of providing a metric for reverse sensitivity or health and safety, similarities there, but I think that's as far as it.
And look, just on that reverse sensitivity question, you did comment in the introduction that there's a debate between the parties regarding what reverse sensitivity actually is. That's what I've written down. Could you just elaborate on that and where you think the debate sits? Because we've seen some of the lawyers and the plaintiffs defining in their minds what reduced sensitivity covers. So where is the debate?
To me, the debate is, does it restricting the operation of the infrastructure, and whether it goes to the point of restricting that operation of that infrastructure, or even this, meaning that operation, that infrastructure ceases operating. That's the debate. The presence of complaints and having to make changes to the infrastructure. That's a grey area amongst the evidence of the submission. Some of the evidence or submission is that it needs to result in restrictions or ceasing operation for it to be a reverse sensitivity effect.
Is your evidence that you haven't seen that type of outcome
No,
in your career?
in my experience, reverse sensitivity can be which can result in a change to that operation, or the operator having to do something to address the complaint. That's a reverse sensitivity. It doesn't need to go to that step of restricting the operation or ceasing the operation. It's reverse sensitivity.
So in your experience, you haven't actually come across a situation where a regionally or nationally significant piece of transport infrastructure had to close down because of the issue?
Nothing comes to mind, but that's just on that. There's an example.
Yeah. And perhaps the transport authorities might enlighten us if there has been. I think there are some examples and some of the evidence, but that's essentially your test. The reality of the future effect that's being talked about and how it might limit these transport authorities. All right, those are my two questions. 2 minutes early, unless there's anything else, Kit.
No, I might have missed where you came down on which side of Commissioner Dacia's question. Is it the potential for there to be complaints per se, which is a reverse sensitivity effect, or is it the fact that complaints lead to some form of constraint on otherwise lawful activities? Can't regulate to stop bad press, can we?
Okay, thank you for that introduction, and we will hear back from you right at the end. So just with a verbal right of reply, piece of our hearing procedure. Right, so Keith, welcome.
Just to clarify the answer to that question, I think you had two options and the witness said it was the former. It is.
He said the latter, didn't he?
The latter, the second option.
That is what I think he meant.
Yeah,
so
yeah.
the former is-
I assumed he meant the latter. He seemed quite emphatic about it, so it's not the complaint alone, it's got to actually lead to something.
I appreciate it, thank you.
Clarify these things if there's any doubt. All right, we're moving to, thank you for attending. We shouldn't have too many problems with the holes, which
Never do so.
I see you've singled me out.
A compliment.
I love a good tirade, come on.
Chairman Dave, Commissioner Littlejohn, Kano, if there's anybody around, submitters, tēnā koutou, tēnā koutou, tēnā koutou. Good morning, everyone, and greetings to you commissioners again. Welcome back to newcomers. I hope you have a pleasant stay with us. So I'm just wondering if I can paraphrase this here. I don't think I need to read it out totally, if I can just paraphrase it.
yes, over to you. It's a short statement, so whichever you prefer. Yes.
In the introduction, so in paragraph 3, I talk about what our original submission was, and that was that nobody bothered to talk to us about how this noise was going to affect our traditional hapu lands, and that it was totally unacceptable to us that we should have to mitigate against the noise made by others. And that's all our original submission was. The evidence that we received on Friday evening, though, has given rise to a few more questions. And that is why I've mentioned that perhaps with annoying Commissioner Littlejohn, we can continue with that. It's worthwhile reading, sir, if I can, paragraph 6, our executive summary. And that is that based on the latest Waka Kotahi evidence provided, we cannot agree with any matter relating to this noise issue because insufficient evidence has been provided. And when I say insufficient, perhaps conflicting evidence has been provided to allow us to make an informed and responsible decision. And I'll clarify that below. In paragraph 7, I say that there is no disagreement with the expert noise evidence provided by Waka Kotahi. Despite Waka Kotahi legal submission saying that we disagreed with the noise, we did not disagree with the noise. I want to make that very clear. You'd be a very brave or foolish person to disagree with the expert evidence. Paragraph 8, the only question then for us is how much of our land will be affected by this noise contour and who is responsible for mitigating against that noise. And I'm reliably informed that the mitigation matter cannot be part of this hearing, so we'll concentrate on where the noise contour is. In paragraph 9, I mentioned that we were led to understand that the proposed 80-metre contour from the edge of the highway would fully encompass the 54 dB noise level. Now that's fine, and we could have dealt with that matter. However, the new evidence from Mr. Charles suggests or clearly shows that this may not be the case, and that in fact the 54 dB noise contour will extend outside the 80-metre corridor. And off script here, may I say I'm a bit confused because throughout the evidence we are hearing about an 80-metre noise contour, yet the plans provided by Mr. Charles talk about an 85-metre corridor, so I'm not quite sure. I'm just a little bit confused. In paragraph 10, we say either this noise is a concern or it is not. And as I previously mentioned, we all agree it is a concern. Therefore, an arbitrary drawn line on a plan will not stop the noise. If we're serious about this matter, then the only way forward is to accept the modelling provided by Mr. Charles and use that modelling, unless, off script, unless the line totally encompasses the 54 dB. So if the 54 dB is 120 metres away from the edge line, then that's where the line should be drawn. In paragraph 11, we talk about the 80-metre contour over our traditional hapu lands may be either excessive or indeed insufficient to determine what areas in the future will require assessment. And again, I say that this can only be determined if we view the modelling effects to see how they will affect our land. So at this stage, until we see those effects, we can't agree with any noise contour over our lands. In paragraph 12, I say the easy way out is to simply remove the noise contour over our land, but that will defeat the purpose of why we're all here. And that is to protect the health and safety of our whānau who may wish to use this land. That said, it may be possible in the end to have a variable set contour distance as long as the computer generated 54 dB noise level is contained wholly within that contour. Paragraph 14, express our disappointment that we seem to be the only landowner grumbling about this matter, yet the Waka Kotahi evidence leaves our land out of the equation. And I wonder why that is. We most certainly look forward to the time when the computer-generated modelling as it affects our land may be forward to us for insertion into our own GIS system so that we can evaluate this further. And in summary, I say simply drawing an arbitrary line on a map, whatever the distance, does not stop the noise. In paragraph 16, I talk about consultation, and we're pleased to advise that following our submission Alan Catchpole, Waka Kotahi Principal Planner, Environmental Planning, has called us and has sent us a letter asking to meet and understand our concerns and discuss the way forward. This is very welcome news. Paragraph 17, I say, and I must add that Alan and I have had a very professional and extremely constructive working relationship over the last 30 years or so. And we're both committed to try and sort this matter out in a reasoned and reasonable way. And through you, Mr. Chairman, I see Alan is here. Alan, I acknowledge you here today. Thank you. And if I can read our conclusion, sir, we believe this hearing must be delayed until such time as a robust and scientific analysis of the noise generated from the highways, particularly as they affect our lands, can be produced so that we can all make an informed decision on this matter. For us as a hapu to make a decision based on what we have before us at the moment would be irresponsible. We are a bit disappointed in the approach the Waka Kotahi legal team are taking with us over this matter, and that's too bad. But in the end, at least something good has come out of this process, because we as a hapu team have completed a full debrief on this matter, and steps have been put in place to ensure we capture the learnings from this situation, and that can only be good. Thank you, Commissioners, for the opportunity to be here today, and I thank you for taking the time to listen to our concerns. That's all I have. I'm happy to take any questions. To everyone here, tēnā koutou. Tēnā koutou. Koutou katoa. Thank you very much. Happy to take any questions.
Thank you very much, Pete.
I'm a little bit confused as to what position you're taking now. Do you want multi-purpose zone land excluded from having these sorts of controls on it or not?
So I think you realise I'm a Bobby Way man today. Our absolute preference is not to have, is to leave our land unencumbered. But that doesn't get rid of the problem. I would rather the noise contour, computer generated noise contour, be identified, and I would be happy to put that on our land if it's the correct method. An 80-metre line simply doesn't wear it. If a noise contour is not put on our land, then we're going to complain and get something sorted. If a noise contour is put on our plan, we're still going to complain, get something sorted. My preference not to have it. I would accept it if it was put on, as long as it's computer generated and it's correct. A Bobby Way, sir.
So yeah, and I'm great with you acknowledging that, because that's how I saw it. I guess one option is, we exempt the multi-purpose zone, which then effectively creates a situation where we effectively allow people to potentially bring themselves to a nuisance, so that then they have an ability to complain, legitimately so, and then that leads you to Waka Kotahi's door, full of complaint and adverse health effect, to try and remedy the situation after the fact, which, be honest and say, is not an ideal, it's not an ideal way for us to do planning. The other option, I guess, comes down to us being satisfied that there is a robust line that can be put. And I think the confusing bit of Dr. Childs' most recent material is that Waka Kotahi have said that because they started with an 80-metre line, they can't go further than that.
That's their scope.
Yeah, and so therefore you see 80 or something less based on where the contour has actually been generated to. Whether at the end of the day that excludes a sufficient amount of land, and whether the 80-metre is the better option, I think we're going to explore that today with the acoustic consultants. But absolutely take your point that you shouldn't draw lines arbitrarily, and obviously we've got to be satisfied today that if that is the approach, then it is the most robust one. Have you had any thoughts about the implications of complying with the standards for acoustic internal amenity that might arise in the case of, because of course to comply with the line, you could just cite any sensitive activities more than the line on other parts of the land. It only really becomes an issue where the land is not that doesn't provide enough opportunity for development outside that contour, if you know what I mean.
We looked at that extensively for the major facility zone, where the noise contour went over our lands. And we dealt with the voodoo noise man up in Auckland, Higley, is it? He called himself. He said that noise was voodoo magic. So we dealt. Higley.
Higley the older, Higley the younger.
Higley the older.
And so we had
We need to
extensive
just rewind the
discussions with
recording
Mr.
and strike that, I think.
and Methanex regarding how that noise should be dealt with and how they were going to sort the matter out, and whether it was double glazing, or if the rooms had to be locked in, then you had ventilation. And as good corporate citizens, they said, you allow us to have the noise and we'll take care of the problem. That's all we're asking for.
Yeah.
You want the noise? That's fine. You take care of it. And that was the crux of our whole first submission. Who's responsible for paying, which is outside of this. So I hope that when either Alan or his colleagues come to speak to us, we can actually get into the nitty-gritty. That's your question.
Yeah, I mean, it does highlight the difference in approach, and it is an issue I want to explore. And I think it comes from, I guess, the statutory genesis of the different infrastructure providers, because that's exactly the same approach that Auckland International Airport has taken, for example, as well as a number of other sort of site-specific designated infrastructure operators. They've realised that where they can't internalise their effects, they need to do something further than the site they control. That doesn't seem to be the current approach with Waka Kotahi, and it is something I want to explore as to why is that? Why do they consider themselves exempt? Is it because of the statutory, the government roading powers that they have this greater ability? But yeah, I take your point. Yeah.
Just to follow up on that, I recall that you had some submissions relating to the meeting site.
Yes.
Those were, they were withdrawn, based on an agreement, future agreement with the side agreement going forward. Was that was generated after the submissions? Methanex, or was that in place prior to the hearing?
An initial agreement came about when Methanex renewed their consents probably 15 years ago. And we discussed the issue then, and we were given a brief letter of understanding, if you like. We simply updated that brief letter of understanding to a more robust memorandum of understanding for future use.
So you worked with Methanex within the submission period and after the
Yes,
hearing?
before, during, and yeah, that's the way it should be.
Okay, thank you for that. I do have a question about child view plans, which we covered on Friday. Now, does this cover do these plans actually cover your properties?
No, they don't, and that was the concern I raised, that we were the only people grumbling about the noise corridor, and unfortunately, plans don't cover our land.
I've been searching for that as
They don't
well.
go far enough forward.
It goes past us, but it just leaves out this, so it's Waitara, and then it goes further north to Uranui. It doesn't cover our particular land.
Because I was looking for that last night.
Would have been very helpful.
Particularly as you're the site, you're given the blocks of land that you pick.
Correct.
And just the other clarification, yourself and the other EV partners looking at moving up from the zone and maybe looking at new sites. And the purpose of that is to allow you to undertake activities, which are pretty broad, aren't they? They sort of do Marai or
Yes.
a whole range of things.
Indeed, and we have a Maryland court hearing in October to discuss that very matter, so that's how close we are to getting things done.
You've only got limited years that come under your control that you can actually build on. That's my understanding from your previous.
Correct, I think we've got about 4 blocks we can build on. 3 of those are within the noise contour zone of State Highway. One is to a lesser extent because it's an access leg, but we have got the 2 main sites that will be extensively by hand.
Perhaps, certainly, Stephen, if you're listening in, which he will be, just want to get some idea about this issue around the Ngāti sites that have been clearly put in play in Mr. Holbridge evidence, and whether a plan can be produced and when that might be able to be produced so we could actually get that into evidence. So we'll deal with that. Or just thinking about who is council, what Kotahi that's you, Stina?
So the only supplements.
Sorry, it's Christina here. You are fading in and out a bit. Could you repeat that? I heard us mention, but we just got a little bit of noise variation. Kit, I think we can hear you quite well, but Stephen, I think you're a little bit fainter.
Yes, it's when I'm turning around talking to the witness. It's and I am fainter than Kit. So my question is, Ngāti Rahiri, through Keith's evidence, has put on the table the particular land areas that they have available for future narrow purpose use. And the plans that have come in on Friday with Stephen's evidence don't include that area of State Highway. So my question is, firstly, why is that? Secondly, can a plan be produced for us, and how long might that take to produce?
It's a very straightforward. Yeah, it's probably easiest just to address it now. It's a very straightforward matter. The plans that were produced just mimicked the plans that were with the Section 42A addendum. So that's why it happened to cover those areas. The GIS file covers the whole district, and that's available now. So it just needs a GIS person to pull out the relevant bit for that parcel of land. That's not a long exercise because I'm not doing it myself. I can't tell you how long. That's what the availability is.
Okay, so you can get that through to us in a matter of days, is that?
Absolutely, yeah. So the GIS file, I can click a button and send it to someone now if someone else has the technology, or I can get the plan set to you within a matter of days. The plan of that land parcel.
Okay. All right. So is there any way you could actually get us a graphic representation today of this land?
I don't have the GIS fingers to be able to do that.
No, but could you get on the phone and ask someone to provide it?
I will try, yes.
Okay, thank you.
Commissioner, can we ensure that the data hasn't been truncated by that 80-metre line so that we know how far it actually does go either outside or inside that 80-metre line?
You get that, Stephen? We're interested in the whole contour, not just what's inside and whether it's 80 or 85, we'll clarify that with you later as well.
That might not be getting back to you by the end of the day, but that's we can certainly do that. Sort of,
yeah, okay. We'll just maybe on the break or something you could come back and update us once you've made some inquiries. Thank you.
Thank you very much.
Thank you, Keith.
Thank you very much.
Thank you for your assistance.
And so can I, at this time, again, thank the Secretariat for the work that they've been doing recently, especially on this one with all this late evidence flying around. It's very, very much appreciated. I personally thank Julie and Christine for it, but just want to make this public at this stage.
Just for the record, I think Christine won Journal Award last week, just as a respectful effort from the council. So certainly it's nice to recognise the hard work. Staying
Well done. Thank you. Thank you. John?
We're now moving to what we have to
Fine,
say. Kaingaora, all these different.
well, as if that was right.
Thank you, David.
Thank you and good morning.
Thanks.
You will have from mid-afternoon, I think, on Friday, rather than lunchtime on Friday, the legal submissions that we submitted. I don't know if you had a chance to read those.
Yes, we have.
Good.
So
So
I
what
have.
Yeah, you know, I could- yeah.
what I might do is,
I drop everything when Mr. Allen circulates.
yeah, right. So I'll speak to those rather than take you through them. And what I might then do is, before we go to questions, I might ask Mr. Stiles on my far left just to speak briefly and give the comments on the material that they hadn't seen when they wrote their evidence, which of course was modelling outcomes and what they know about, what they understand of it. We're in a slightly unusual position in that you might normally expect Waka Kotahi to put that material. It's just the mechanics of the hearing and who goes first, but we'll do the best we can.
Yeah, I mean, it is something that occurred to me that given everyone has sort of been braying for a model and it turned up as the last piece of evidence, and I assume that Mr. Stiles and Mr. Lloyd and Dr. Charles haven't had a conversation about it, whether we're actually going to be hugely assisted by everyone talking about it in the third person, whether there needs to actually be a conversation amongst the acoustic experts so that they all understand the basis upon which it's been. It may be that John is confident based on what he's seen that he knows how it's all been done, or it may not be, but I think we just need to play it by ear a little bit. I'm certainly not going to be satisfied just having a lot of people talk about Stephen's model without actually having some interplay and interaction about it, particularly if that's where this is potentially going to end up. I just think that would be foolish.
And that's understood. I think Mr. Stiles has a reasonable idea of what's being done, but some of the nuances he may not be aware of.
Is that the voodoo?
Don't do voodoo.
Voodoo and Higley in the same sentence? I mean, it's not something I've heard before, but
Special day.
it works.
Before I speak to that, can we just say thank you to you and to the council for endeavouring to put this on right at the end of the process, because I think it gave us a chance to have some discussions, most notably Whangarei, haven't finished yet, and some other things around the country. We had hoped, from our perspective, things might have resolved completely. They haven't. But nevertheless, I suspect the range of material in the evidence has probably benefited from a degree of understanding on all sides. So it may not look like it, but I think we might be closer than otherwise we would have been. Thank you for that. I won't take you through the submissions, given that you've read them very recently by definition. I want to start by making a brief comment that this is, as you will have perceived, in a sense, a universal issue, in that it's not specific to this district. It's not specific even in the case of roading, just to state highways. If you've got 25,000 vehicles a day on a state highway and 25,000 vehicles a day on a local road or an arterial road, they have the same potential effect. Subject, of course, to the issue about speed, but this is not a case where, as I understand it, what the Kotahi is saying, you can put the rules in the rural area only and forget about the urban areas. And clearly around the country, there's discussion about the urban areas. So that tells us, and I'm sure all of us would see it, that it really tells us a national resolution to it. The irony, of course, is that we have no national resolution, no national level documents on this issue. We do have Parliament passing legislation about more specific local agreement like housing. And yet this is an issue that has a broader relevance. And one would hope that at some point we will get some sort of national level guidance and it will clarify things, because one of the observations I have, and I'm involved in some of these, and I know that what the Kotahi, Kiwi Rail are involved more generally throughout the country where they have interests, is that we often end up with slightly different mixes. Well, in some cases you get no controls. The Auckland's unitary plan doesn't have any. And other places you get particular controls. And in the third sort of category, you get a mix of things where councils are trying to figure out what's the most appropriate course. We've got a series of inquiries that are almost duplicating themselves and not necessarily ending up the same result, because understandably people have different views as to where the best set of provisions might be. And of course, none of these processes to date have involved cross-examination. They haven't involved the full sort of inquiry that the court would enable. And while we have matters that are before the court in the sense of appeals haven't been lodged in both Whangarei and Waikato district, that I'm aware of, and probably some others, we don't yet have any findings from the court that then give us some guidance. So it is a difficult position for everybody to be in. The one thing that we would say, and that we are arguing, is that there is a local context to these issues. And the issue most notably here in terms of rail is, do you reach the point where your concerns are significant enough that it warrants a rule? You get over the Section 32 hurdle. Is the most appropriate thing to do a rule, or is this in a circumstance where in fact you just leave it to the discretion of the landowner, because the effect they would be affected by will be of such a minor degree that it's their call rather than the council's call. And of course that comes down in the case of rail to the frequency of the trains and the length of the trains and the speed of the trains and the state of the track and all those kind of things. How much noise is being generated? What's the receiving environment? That kind of thing. You raised a question before about, and it comes through in the submissions for others, as to, well, once there's, in a sense, a theoretical issue, is it appropriate to just put the rule in anyway, because we don't know what's going to happen in the future? I think we need to come at that issue with a degree of realism, and both in terms of what's happening now, what's likely to happen in the future, but also in terms of time. So what's the time frame we should be thinking about? And the logical one, I suppose, is a life plan. What is the realistic expectation in terms of use of this resource? And in this case, it's obviously rail, which is relatively lightly used at the moment. With possibility somebody will change that dramatically, might remove the road transport regime that we currently have and go back to one we used to have. That would be quite dramatic. It's most unlikely, but those are sorts of things that theoretically apply. But I think maybe a useful place to start is the question we have in terms of the fancifulness of activity. What's a realistic position to be in through the life of this plan? And in that context, we would say, and Charles Evans deals with it, is that we don't think we've got to the point of evidence that tells us we have a genuine problem in terms of rail. The issue is a little different, obviously, with roads, because we use roads a lot more and a lot more consistently. We do have trucks on them, we do have buses on them, we do have cars. So there's a more obvious issue to address in terms of road. Can I just briefly then reiterate what I've said in the submissions about this being a health and amenity issue, not a reverse sensitivity issue? And perhaps one place to go to is 413 in the Kiwi Rail Holdings submissions. It's the last paragraph in the section there on reverse sensitivity. It says, rather than waiting till there are enough complaints from communities that are unhappy or unwell, planners and councils should be proactively managing adverse health and amenity effects from rail noise and vibration. Do you agree with that so far, in terms of the extent that you need to be comfortable that you've got an issue, obviously, but once you have an issue, you should deal with it. In terms of health and safety effects, but it goes on to say in a way that minimises the potential for reverse sensitivity and health and amenity effects to arise. So the health and amenity effects is something that we recognise as the potential to occur, and if it does, we need to deal with it at the appropriate level. That doesn't mean you have a reverse sensitivity effect, and we're not saying you need to close the rail down, you need to close the road down for it to be a reverse sensitivity effect. Obviously, it can be less than. But there are certain operational matters that will be undertaken, operational steps. There will be certain physical steps in terms of the quality or the nature of the seal you use on the road. Whether you have walls alongside it or noise bumps in certain locations. Those are things that you can do, and those we would say are the things that ought to be done in terms of BPO, best practical option, for these resources, for these facilities. And the fact that you take those steps to deal with the effects that you are generating on your neighbours doesn't mean you're suddenly the victim of reverse sensitivity. There's a difference, I think, in quality and quantity there. The obligation to carry out BPO, I think, needs to recognise the area you're going through. If it's urban, you might have a different response from rural. And clearly, roads tend to have different speed limits. They tend to have often very different finishes to them. They will tend to be quieter in many cases. That's appropriate. And in many places, the BPO may well be being used now. The other thing that comes into that mix, of course, is that people living alongside these roads may or may not want a wall that's an acoustic wall between them, because they might get a benefit in terms of noise, in terms of acoustic wall, but they might get a disbenefit in terms of their ability to use their front garden or to enjoy the view out on their property. So there's a degree of discretion that residents will want to exercise in terms of the level of noise they experience outside, particularly, potentially inside as well. So we say that there's a grey area between just having to stop the activity in terms of reverse sensitivity, which is well beyond the level you need to get to show the reverse sensitivity, but equally just receiving complaints, I would say, is not reverse sensitivity. Having to schedule those complaints, having to write them up and think about what the response is, I don't think gets us to reverse sensitivity. But in the middle there's an area where, yes, your operations and the way you build things legitimately reflect the BPO, and then do you need to go beyond that to something else where there's a further imposition on the way that you operate, and that might be where an issue of reverse sensitivity potentially would arise. But our position is that we don't have evidence that gets us there. We don't think realistically this is about reverse sensitivity. We think it is about the thing that's mentioned, I think, 3 times in that paragraph, 4.13, which is health and amenity effects. And that's the material that Charles, Mr. Stiles, and Mr. Lloyd address, really. And the other thing I would say there is that in terms of health and amenity effects, again, there's a level where it might be incontrovertible that there's a health effect because the amenity effects are so severe that people sleep properly, or they are affected in some kind of stressful way. Then there's just the discomfort you received, or the fact that you register noise outside. People have varying degrees of familiarity with or comfort with noise, and there's a point at which we need to allow them to exercise that discretion or to determine themselves whether they're able to be affected by something. I appreciate that for some people there's limited ability to choose where you live, and often living alongside a road, major road, might be where the cheaper housing is. But I think for most of it, there is some degree of discretion that's exercised in terms of where we'll be able to live and the extent to which noise is an important factor for us or a less important factor for us. Now, that variation, in a sense, is inherent in the way that these rules have been put forward by the transport authorities, in that there is an argument effectively says the minute you get to whatever the limit is, 54 dBA, 57 dBA, whatever number we're using to get the place around the country, the incoming person needs to build their property in a way that means that their noise amenity is at a certain level, because they must be affected to a point where they must be protected. But the people who live there now clearly aren't affected enough for the generator is to go out and say, I think it's time that we upgraded your house to remove from you the potential to have your health affected as a consequence of the noise that our road is generating. The situation that we had in AIL, in the Auckland Airport case, and there are others around the country where the generator of the noise takes responsibility for mitigating that noise in part. You can't remove the sound of planes flying overhead, but you can do something to the buildings underneath it. And in that case, and in these cases, typically with roads, the transport's going up, the amount of noise generated goes up over time, people are still living there. But there's no suggestion that the people living alongside those roads will have the effects upon them mitigated by transport authorities, as you said earlier, doing those mitigation works now. So I think in the context of this issue, there is quite a big grey area between the point where the rule comes in for the people building new houses, as proposed, and the point at which it becomes incontrovertibly a health issue that something needs to be done about. There is an amenity issue in the middle. Planning sort of deals with where the lines should be in that middle section. And one of the things you'll notice that Kāinga Ora is seeking is if we're going to have rules that say apply to the urban area, particularly because that's obviously where its greater concern is. We're going to have that, and new builds are going to have to comply with these rules. There's no proposal for existing builds to comply, but there is an issue about what happens when somebody expands or extends their property. If I want to build on another bedroom to my house, do I suddenly then need to pay the cost of mitigating the effect created by the road next door when the mitigator isn't paying to upgrade my new room or to upgrade my old room? But I apparently need to spend money to mitigate the effect generated by somebody else. So part of the relief that Mr. Campbell's suggesting is that there be an exception for up to 25 square metres, new habitable space or similar, being attached to an existing house. Without that, in the circumstance where the person who owns that house and is doing the extension has the discretion as to whether to upgrade it to a level that equates to whatever the rule is or not, because they might be entirely comfortable with the current noise environment. We think that issue about existing dwellings is a particularly important and potentially difficult one in the absence of an obligation on or a taking on of the obligation on the part of the noise generators to say we will resolve that issue for existing. Let me just see if I've make sure I covered. One thing I did note, in terms of the BPO, in terms of things like fences running alongside properties, if you've got, for example, a state highway running, let's say an urban area, and you've got a series of houses alongside that face away, we're typically getting a position where there are fences that are acoustic fences that are constructed along there. The most efficient way to do that, of course, is for the roading authority to do it, or the rail to do it. They can build the same quality fence in one go, more cheaply, more effectively, more efficiently, rather than leaving it to individual landowners to build the best fence they can or the one that they cobble together. So there's a lot to be said about trying to deal with those matters in a comprehensive way where it's the appropriate or most appropriate way of dealing with those effects. I have to say the modelling approach that's coming on Friday is something that Kāinga Ora prefers, and one reason for that will be apparent to you when you look at the modelled maps. In the urban areas, the amount of land that's covered by the control would drop by something, maybe 40%, maybe 50%. It's a really significant reduction. It is based, of course, on where you've got buildings and landform and the like. We appreciate it's far from the finest detailed piece of modelling that could be done, and that the cost of that becomes very significant. But it is a modelling at a level that clearly provides more useful information than an absence of modelling. And simply applying a standard figure tends, we think, to impose on far more houses than it needs to, obligations that they otherwise wouldn't need to undertake. And of course, the cost of determining whether you need to do anything more involves the voodoo work, whether it's noise from railway or noise from road. And it's much better that that cost be identified only on the land that's most likely to be, to really require it to be carried out. So the benefit of the modelling is it does reduce the extent of land where these rules. The other thing we should say, and the evidence is very clear, is that we don't consider that vibration is something that got to the point where the most appropriate thing to do is the rule. In the case of road vibration, it is something, as you see from the evidence, the road authority fundamentally involved. In the case of rail vibration, it is more difficult because trains occurring, be longer, heavier, transmitting through ground conditions, and one of the things we've learned through this process, I've learned, is that it is more difficult to determine where you're going with vibration in terms of rail. It is also, of course, hugely, it's a very expensive exercise for the landowner to deal with, both in terms of identifying what the vibration issue is on their particular piece of land and then responding to it in a way that meets certain predetermined tests. So vibration is really problematic. And again, start to take that more detail. I think that covers things I felt important to say. Otherwise we
The prospect of the vibration rule, I had for rail in particular, I had to chuckle. One of our site visits we did earlier this year was for a completely different reason. It was some of the buttresses and bridges for some of the old railway bridges had been identified as of historic heritage. And so we were out traipsing around the district looking at these old railway bridges. One of them we came across was right down in the middle of the city, where a large DIY store, was it a Bunnings or a Bunnings, had been built over the top of the railway line. And was probably a great, probably some form of easement or something, but I had to chuckle when we were getting into the evidence about the vibration here, about the shoppers in that building when the train goes through the underneath the floor. Anyway, unnecessary levity. Sorry about that. Probably the questions I had are really things that I'll probably talk to your witnesses about and then come back to you on, Mr. Allen. The way you put it was quite helpful in that this is not about finding a way to relieve the infrastructure provider from having to achieve the best practical option. Yeah. But there comes a point at which what might arise in terms of complaints would arguably press them further than what would otherwise be required under the best practical option. Because when you think about it, there's obviously surface treatments, let's think about roads, and then there's speed limits. And once you've effectively, porous asphalted your road and reduced the speed limit to 50, you've potentially raised the cost of that piece of road quite significantly, and you've potentially made it less efficient because everything's got to go slower on it to some extent. And I guess that's the real challenge, is trying to come up with provisions that address those, the grey area, as you said, beyond what is otherwise the legal obligation of the infrastructure provider, and not going further than that to some extent. It's a bit of a tricky one.
And I think if you're using a form of noise reducing seal, maybe that's appropriate. Maybe that's where we should be in 2022. Particularly in urban areas. I mean, and if you're driving around New Zealand, compared to driving in pretty much any other country, first world country, you notice that our rural roads are really loud. Because we use
We're not a first world country. We think.
well, fair enough. Very good. Let it be there. So perhaps there's certain standards we should be by in terms of the way we build. The other, in terms of
roads.
speed limits, well, of course, in urban areas, we've got a range of factors that come in on that apply as to why you might have reduced speed limits. The other thing, of course, you can do in urban areas, but you've got to be very careful about it, is acoustic fencing and along motorways. That's appropriate. Along major roads where we now have an MPSUD telling us that we need to intensify in centres, and in the case of Auckland, at least a recognition that that also means intensifying along corridors, you end up with a tension between the intensification and the road that's generating the noise that potentially affects these people who are living in this new intensified area. So there are a number of planning issues that are sort of coming into conflict. Now, if you're building a new apartment building alongside one of those roads, it's appropriate that you take appropriate steps to ensure that the noise level inside the apartment building is fine. And I've come home hotel overnight in an hotel, and I looked outside in the morning, thought there's quite a lot of traffic, but I'm not hearing it really. So that is building clearly well insulated. The issue in terms of fencing is that some places it's not appropriate, but it may well be that equally the speed limit is going to be lower as well, because you have people living on that street, or you've got people walking along the pavements alongside it, and these things come together and produce an outcome where, for a number of reasons, the speed limit is lower, therefore the noise level ideally is a bit lower, therefore the need for mitigation may be. I think the gap between BPO and what you might be required to do in terms of a reverse sensitivity issue is, I'm trying to think what would be in that upper category in the context of roads, because
Move the road.
well, or build a bypass.
Build a bypass.
Right, but then again, when you're building bypasses, it's not usually because of noise.
No.
It's because of traffic
volumes.
Absolutely, and because of traffic time. So Hamilton's now bypassed. I'm not sure how much difference it's going to make to noise levels in Hamilton, but it clearly has other benefits in that circumstance. So in my view, we are dealing here particularly with roading, because rail is much more dependent on location and the extent to which you use it. The fact that you've got a track doesn't necessarily mean you're getting a lot of use in it. But with road, we're in a position where it is such a fundamental element of how our cities and how country functions that you're not going to lose it. It's probably going to win most battles in terms of these trade-offs. There's a point, though, where imposing more costs on the neighbouring landowner gets to the point where it's inappropriate, and it isn't the most. You should ultimately leave that decision to the landowner. If you're not going to
Or to the regulator, and we get a change to the building.
indeed, and I
Or
think
you have a building code provision which talks about acoustic, amenity, and you actually have acceptable solutions to deal with it based on where you are.
and that in a sense is part of that national package that I think logically we should probably be getting, but we're focusing on other grander things at the moment instead of this as an issue. But yes, you're right. There's possibly an NPS or an NES, and there's possibly building code issues that might address this kind of issue. But clearly, it's not as if you drive off the state highway onto a major arterial that's council owned, and the issue goes away.
Yeah. Thanks for that. If you have a question, go ahead. Yeah.
Two questions for me, Douglas. The first one relates to this Auckland National Airport Limited situation. Now, my understanding is, were you involved in that, or you?
I was, a long time ago, and I was involved for Ministry of Education.
So my recollection came up in the Christchurch replacement district plan where I said that was that was what those provisions were actually volunteered by the company, not imposed by any court direction.
I think volunteered is nice.
Well,
We had endless, we
well,
had,
volunteered in any, put it that way.
right, we had designations, and including in that was a designation for a requirement for a second runway. Well, second set of runway. We had a series of rules regarding the zones as well. And there were extremely lengthy mediation process, if you like, between Housing New Zealand was involved, it was in Ministry of Education, maybe in their housing. Manukau City Council, as it was, Regional Council, the airport, and a range of other parties. And that issue arose in a sense because the airport was wanting something more, and it was wanting designations. And at that point, of course, you can concentrate on the designation conditions, whereas in this process, the designation conditions aren't up for us. So you can't impose things on them. But there was a recognition, I think, through that process, very clear recognition that the consequences of the airport were going, in terms of noise, were going to increase, and a balance needed to be struck between obligations on landowners in terms of the Hana and the Mana, high noise, higher noise, and the medium noise areas, and the obligations on the airport with particular reference to existing resources, so existing housing and existing schools. And there was, in fact, an area of land where there was prohibited activity status. I think it's now being sought through the unitary plan, I think, for intensification, which is interesting the way that it's just quite close to the airport. So there was a mix of policies, but it was an agreed position in terms of
Agreed, okay, agreed by consent.
Yes,
My
indeed.
point that it wasn't, what didn't arise through a court process, did it?
It didn't. The only thing we had was a reasonably lengthy discussion by Judge Shepherd, and I can't remember the extent to which he went into the merits of that or not. But it was an agreed outcome. It was not a disputed hearing.
So, in the legal submissions, you're not relying on any authority at all in these submissions, are you? Is there anything that can assist us? Because this, as you said, this is this issue has been around since Adam and Boy, in terms of certainly when I was a boy, a young planner. So there's no authority that we can rely on.
No, I don't think any of us found anything that says this is how you should deal with this, which is why we're
That's why we're still here doing
certain
cases.
cases. I think maybe Russell McVeigh gave us, but I went through them and I didn't think they.
Yeah, I'm interested in what bits of them. Some of them are 150 pages long. I'm just wondering which bits can help.
There are some paragraph references, and I found them, and I
I have a property to solve one of those cases, so I know.
But I don't think there's a statutory, sorry, there's a case law answer to this, and which is why we're all fishing around all over the country trying to find.
Right, so that's, I think you just confirmed what I've worked out. But secondly, you made a comment about designations. These state highways and railways are designated in the plan. Yes,
I'm not sure. Yeah, they just, I'm sure the state highways would be.
you say that the conditions haven't been up for consideration, but these were all the designations were up through the process of plan.
But sorry, in this.
And parties could have lodged submissions on seeking further designation questions, conditions. And was that considered by Kaingaroa as a technique or as a?
Why not?
Just briefly, so the approach we've taken to the submissions is that today is that we wouldn't be seeking further conditions on the infrastructure providers because infrastructure is needed for communities. What we're struggling with is the flip side.
Yes.
Is that they're seeking to impose controls that they weren't imposing themselves on others.
So what I'm trying to establish is that that was an opportunity for any party to lodge actions, seeking conditions on designation.
Have been, yes.
Yes. Okay. That's fine. My last question is, I'm having one. Your last paragraph talks about these other processes.
Yeah.
Pretty close contact with some of the other chairs that are hearing these matters around the country. Did you act, Douglas, for both Kato and Whangarei?
Yes, we did.
So which side of their decision did Kaingoa fall on? Were you comfortable with the?
In Whangarei, the decision was not to impose rules, and we didn't feel, obviously, we agree. But what Tahi and Kiwirau had,
Yes.
their own discussion.
Waikato?
In Waikato, there were some aspects of noise memory that are in there in the decision, but I'm not feel on Waikato. And that process has only just started, so we have, there are no discussions on that yet.
So those appeals, both of those are somewhere in the here.
Yeah, Whangarei is the potential, well, I suspect Whangarei is next year because Judge Smith is dealing with things and he's busy on some other things, so.
Okay, thanks for that.
Okay.
Right.
Next, I asked Mr. Stiles and perhaps address you briefly on the further information that you've got, if you can.
I'm going to try and deep voodoo it.
Just hold it up, my pen's run out, so we need to grab another. Right.
So I thought it might be helpful to break up my few points to you into the people areas, which are road vibration, ground vibration, noise, road noise. And that's an order of increasing degree of difficulty.
Before you kick off, just to be clear, you've done a primary statement of evidence.
Correct.
You've done some rebuttal evidence.
No.
No. That's so.
Just before I go into those 4 areas,
But so, yeah,
there's just been that talk this morning about Auckland Airport being an example of where the noisemakers meeting either entirely or contributing to the cost of mitigating noise effects on existing houses. A whole bunch more cases that I'm aware of, including Port Napier, Wellington Airport, obviously Queenstown Airport. I haven't, in the few minutes I've had this morning to check on how it all came about. I can't be certain about some of the others and how they were derived, but those 4.
Yeah, I mean, all the other ones.
yeah.
And most of those are, my experience is that they all arose out of circumstances where the provider wished to expand and needed new permissions. And the advice they got was that they couldn't, in good conscience, impose that impact on people. And so as a good corporate citizen or whatever, they needed to resolve it. I mean, both of those port ones, I think, were all resolved by consent too.
There is one other that's unfortunately still in the process. I can't talk too much about it, but it's not the same as that situation, but it's
As an existing use, sort of like the situation we've got here, where you've got a base load effect that we've all quite happily lived with for hundreds of years. And now we think we ought to do something about it.
It's not Whangarei, just for the avoidance of any doubt or speculation. It's an entirely different case. So maybe if just starting with road vibration, I think for me that's the easiest one. As I understand it, what the Cafe is still seeking those controls and the council are. My view is that there's no empirical or predictive evidence to show there is an effect significant enough to justify those controls. That's set out in my primary statement. As is the fact that I think that most, if not all, potential road vibration issues can be adequately controlled inside the road corridor. The cost of those vibration assessments and the mitigation have not been adequate. I think I say in my evidence that the cost of just doing the survey to see if there's an issue is 3,000 to 7,000. Then if there is an issue, isolating a single level dwelling is going to be that order. And then you might find, but this is my big concern, that the pothole or defect that gave rise to that problem is fixed next year as part of ongoing maintenance, suddenly there's no issue. So I have a real issue with that road vibration set of controls. Rail vibration, essentially the same issue. The difference with rail vibration is that it's more likely that there will be effect outside the member. It is more likely that there will be an effect outside the member. Measurable vibration. But the critical issue with rail in this district is that my understanding is that the frequency of trains and their timing in the day, which is also important, because during the day it's much less of an issue than night. Both of those factors combined and the speed of trains on a significant portion of the network, but so low that the controls just aren't necessary. There's only 2 trains a day, in my view. Still a fair way off needing control. I think I'll be back in front of you next week on the seaport issue. See their 2035 forecast is for 2 trains per day. Not short and not slow. So, as I say in my primary statement, I consider the control sought by Federal rail noise, again, the same issue. Comes down to the train numbers, the speeds, time of day, at least for a part of the line. See that there is justification. So road noise, this is the one where there's been a bit of change. The modelling that came through on Friday, from my point of view, is very welcome. I think, as Mr. Allen mentioned, my estimate is that for the areas covered by the blue contours, which are the lower speed, looks to me roughly like about a 50% reduction in the land area covered by that control, which I think is the higher speed environment. It looks to be less. It's a little hard to gauge, maybe 30–40% reduction. There's still some issues, though, that those contours don't address. As I understand it from this morning, in contrast to the council, I support controls on land adjacent to the state highway residential zones, regardless of the speed limit. That's to try and help deal with the existing situation. So that as that housing stock is slowly upgraded or turned over, then the internal environment for the occupants will. Noise modelling is based, as I understand it, on the existing road surfaces and the treatment of the road corridor. There'll be a bit of discussion this morning about how that might not necessarily represent BPO. Mitigating the effects inside the corridor. Maybe some other opportunity for those controls further. And of course, another point that's been dealt with this morning already, the controls don't manage the effects on a significant number of existing or sensitive activities that are already affected. I don't think that needs any more explaining as far as I can see. And there's obviously going to be some minor drafting that will need to be sorted out to take account. So those are the headline issues. Actually, there's one other, and it's about the modelling.
Sorry, excuse me,
Have a
sir.
discussion.
Sorry to interrupt.
Yes.
Ms. Arthur Young here. Good morning. It's really hard to hear. Mr. Stiles, if he could speak into the microphone, and as well, I can hear Commissioner Littlejohn well, but not Commissioner Daish. Grateful if folks could speak up. Thank you,
Yes,
sir.
and just on that, that was the reason why we were keen to have people in the room. These hybrid hearings are a problem for us. We do give authority to come in by Zoom when there's a reasonable reason for that. But we certainly have struggled with these hybrid hearings, and certainly that's much better if we're all on Zoom or in the room. So look, we'll just continue to do our best. It is what it is, and yes. So let's just carry on. Thank you.
One, it might be useful for us to know where the microphones are.
Well,
Is it
they're all up here.
They're all up here.
Yep.
Yes.
So,
Christine.
yeah, we have had of course, some technical issues, and we have had them have a look at it. And speakers are on the sides here, and they did increase them some, and we thought it was going to help. I have had Jan online this morning, and she's been hearing what's been sort of this morning as well. But we did try, and it looks like they're still going to have some issues that they're still going to work through.
So the speakers are in up here. Is that? Oh,
No,
no.
it was where the,
No, that's not the microphone.
no, just on the side.
Christina, is the transcript, the Zoom transcript, is that clear? Or is that, have you looked at, since the
Personally,
changes been
myself,
made?
even I have a voucher.
All right, well, just keep reminding us.
Yes, sir.
We'll try and speak up.
Thank you,
Mr.
sir.
Stiles has to raise his decibel level.
I know I was about to make a terrible DB joke, but I thought it was not very funny. We can hear some parts of the room quite well, so thank you, sir, grateful.
He is a very softly spoken acoustic consultant. Someone had to say it.
I just have one more point to make, and that is regarding the modelling and the technical side of it. I understand from Dr. Child's evidence that he has had a conversation with Mr. Lloyd last week. Excuse me. That's set out in his statement from Friday. I haven't had a conversation with Dr. Child, but I have had numerous conversations with him about the exact same modelling approach in another district. So I haven't had the opportunity to check it to make sure it all makes sense, and I think that's the QA checks that Dr. Giles was talking about. So I haven't had that opportunity. He hasn't. But I am familiar with the general approach, the methodology, the way it's been constructed, the inputs. At a principal level, I'm very comfortable.
Thank you. Question for Kit.
I would like that in writing. If that's possible.
Well,
From Mr. Stiles.
Just the last part.
Yeah, just ideally, I'd like you to have a conversation with Mr. Childs about it, but I guess let's see where we get to
Yes,
today. I don't want to produce more material, but I think this is quite an important point. Because particularly if we accept the proposal, then we are effectively buying ourselves into creating another overlay layer that would have to be GIS inserted into this entire plan. And that's, I mean, I understand it's doable, but it's going to take a bit of work. That's all. And I think we don't want to do that unless we've got general agreement amongst the acoustic consultants that the outputs of this modelling are defensible enough to sit as a layer in the district plan.
Look, I think we should proceed on the basis that we almost will certainly want a further statement from the three noise experts regarding this modelling, and we'll talk about the timing of that through the day, and perhaps at the end we'll sum up on that. But it seems to me that just with the parties have been working closely together on a number of places all around New Zealand. We've now got a modelling approach, which I'm not sure whether it's the first output that we've seen. Not first, but there's other outputs. And certainly it's come in really recently, and I would like the Lloyd styles to actually have the benefit of looking at it. I think probably the best way to do that is ask you to do a joint conference and the statement, but that will have to be done pretty quickly because we've got, we're closing these hearings this month, so we can talk about it, but I'll signal that that's a likely outcome.
If I may, there's in the other district that we're going to talk about, and Dr. Charles alludes to it, there is a modelling plan that sits behind these outputs. And it talks about the way the inputs are treated and the way that the contours are smooth, the way buildings are dealt with. In my mind, that document is a key component of all of this, because that sets out exactly how the modelling was derived. And if this is going to go into the plan, I think that document needs to be part of the process so that everyone understands how it's derived.
Has that been produced, like, you're talking about Florida City? Modelling to you?
Whangarei is part of it.
Whangarei is part of that, those discussions. Right, well, we'll need to take some advice about what might be required for us to have enough certainty to make a good decision on this in our time frame.
Well, I was going to suggest that I would anticipate, Dr. Charles can clarify, but I would anticipate he would have that plan available. It's a short document available.
Yes, based on the Whangarei example.
That's right, and that I would say it's likely that Dr. Charles, myself, and Mr. Lloyd could probably look at that, agree on it, because it's been refined pretty well, and submit that to you as part of what we agree on. Clearly, that's going to require the cooperation of.
We'll hear from the other parties, but that's been good to get that on the table early. I do have some other questions, but
Yeah, I appreciate your summary, Mr. Stiles. It's very helpful. I guess the two things. One may be more for Mr. Campbell, but I just want to talk to you about reverse sensitivity when it comes to roads. We've had from the evidence, I think Dr. Charles refers to 2 instances of some complaints about roads, and I'm going to talk to him about what they led to. And I think Kiwi Rail's witness, Mr. Hancock, talked about some other issues of complaints about use of the road corridor, and I think one particular one about some people complaining about a new level crossing bell that went in, and I was wanting to talk about, well, what was the outcome of that? But you've been working in this field for a modest 21 years, I think you said. Modest 21 years. Have you come across any instances where road or rail infrastructure operators have had to fundamentally change the service they provide or what they do with their corridors as a consequence of a braying mob?
No, I've obviously thought about this answer already because it's a hot topic. I've been involved in quite a few situations where there has been discontent about noise from infrastructure. Level crossings are a regular feature in that. But not train movements or train timings or train speed or anything else related to the movement of the train. Similarly, in terms of road, can't think of anywhere the fundamental operations had to undergo a change as a result of complaint or discontent. I have in the past raised the example of the Ellerslie Noise Wall, which we've constructed in Auckland in the absence of any other capital works project going on. So there was
that reference to
the noise walls alongside the Southern Motorway in Ellerslie on the
okay.
eastern side.
They seem to be going up, they go everywhere, don't they? Yeah.
They're mostly going up where there's a road, where there's an extra lane, or where there's other similar goods going. Ellerslie was a case where it was undertaken independently of any other work. And I think it was permitted, except for some technical earthwork control or something like that. It was nothing to do with noise. My understanding is I was directly involved in it, but the residents, I'll call them, had lobbied for some mitigation, and the agency had said, okay, essentially, we'll build that, fund it, we'll build it. Whether that was, I think this sits in the grey area, whether that was a reverse sensitivity issue or not, I guess it probably takes a legal view to determine that ultimately, but the project was described as necessary to adopt the BPO. That's how I looked at it from my perspective in reviewing it for council. So again, though, that's not a fundamental change in the way the infrastructure is operated. That is installing some mitigation.
Presumably the alternative was for Kotahi to go and make offers to all of those residents to acoustically insulate and provide ventilation to all of those homes that might have been affected.
I don't know if that was on the table, but it's an option.
Thanks for that. The other question comes to the observation that Mr. Allen made at the outset, that there are roads everywhere, and yet we're only here contemplating potential controls on buildings adjacent to some roads. And I'm assuming that's simply because that's the way the submissions have fallen, and no one actually proposed a road zone as far as I'm aware. So I must say, I do like to have things ordered, and given that we've got an activity being caused by the use of exactly the same infrastructure, and the only difference between it and what we're talking about here is the legal operator of that infrastructure, it just, I must say, it does cause me a little bit of disquiet as to whether we're being a bit unreasonable in the target we're looking at here. I mean, you have any thought? I mean, it was probably a question more for Mr. Campbell, but it sort of does. Am I wrong to think that this is not being evenly handed here?
Can I just suggest that you go on that over the morning tea break? I've had way too much water this morning.
Oh,
We need to have a comfort break. So we'll come back about 11:05. Thank you.
Clear the exits.
Yeah. Thank you.
Right.
Thank you for that indulgence, everyone. I think I'll not be the only one that was hoping for a break. The old dad used to say to me, speak up now or forever hold your peace. So you spoke up. I spoke up in the middle of a Q&A, so apologies for that. John, have you got enough to come back on, or do you want to paraphrase the question and you understand it, or start again?
But so I give you the right answer. Can we start that again?
So it gives you
The right answer.
Right question.
I always love it when a witness wants to give you the right answer.
That's what I mean.
Yeah. Oh, no, give me the wrong answer. I actually thought about it, and I think it's more of a planning and policy issue than a pure acoustic issue, because it comes down to coming up with some form of basis as to why you would apply some controls to deal with effect X in this circumstance, but not the same effect in a different circumstance. So I think part of the answer might be a legal one in this case, but it's sort of a variation on the question about why you would do it for roads that have a speed limit over 70 kilometres an hour, but not under. comes down to what's a rational basis to differentiate between a control when you're talking about the same effect. So I think it's more of a planning legal issue. So I don't need to trouble you, Mr. Stiles, unless, of course, you want to venture an opinion on it.
I think there is a small technical element to it.
Okay.
I'm not going to venture any opinion, planning or legal matter. But I'm sure Dr. Charles will have intel on this as well. But in my experience, state highways are far more likely to carry traffic volumes that are much greater than local roads, very generally, of course, and a much higher percentage of heavy vehicles, which are a major noise generator on the open road section. So that's not universal. I'm sure there are going to be sections of local road that do carry enough trucks and cars to make this an issue, but it's far more likely on a state highway.
Okay. Doesn't the modelling accommodate that by showing a smaller contour over the local roads? Or over the state highways that go through the urban areas?
That's that smaller area covered by the contours is a function of the effective built form, speed, road surfacing. Primarily those three things.
Thank you.
Can I just offer one more thing, and it's just a reflection very quickly.
Sure.
Before the break, I told you about my experience in the Ellerslie noise wall case. And I just went back and had a look at some of the documentation, and I can't find anything that talks about pressure or complaints being a justification for that project. In the formal documentation, it was all about, we're putting up some noise walls, we need an OPW, going to reduce the noise effect in the community. That's it.
An OPW?
Outline plan.
All right. But it was, the documentation does mention it was based on a BPO analysis. Okay. So that's okay. So look, I do have one other, one supplementary question from Kat. The future modelling, I presume, or you know, the future modelling anticipate any changes in the vehicle fleet, heavy vehicles running up and down highways on hydrogen, or expansion in our electric fleet.
Dr. Charles will give you advice on that. I understand it's the same approach as it's undertaken elsewhere that I'm involved with. And if that's the case, the answer is no. The reasons for that are, it's not certain what the uptake will be and over how long, particularly with heavy vehicles. With cars, it's the difference between an EV and a combustion engine car is not great in terms of noise emissions, because it's more about the interaction of the road and the tyre. With heavy vehicles, the difference is much more pronounced, particularly at open road speeds. And depending on the ratio of heavy vehicles to light vehicles, you might see a 3 to 5 decibel change for 100% uptake on EV or hydrogen. So it becomes reasonably significant on the open road side,
but less so in the lower speed environments.
Again, I think Dr. Charles will probably have advice on that for you as well from the modelling process.
Okay. So are you aware of the new hydrogen ecosystem that's been rolled out for heavy vehicles in the North Island? The Ringer is a new company is looking at hydrogen fueling facilities throughout the North Island State Highway.
Yes.
So it's not a fanciful thing that sometime in the future we might be seeing less noise from these heavy vehicles.
I don't have a view on whether that's fanciful. I mean, it seems sensible that it's on the way, but whether there are real impediments to its uptake or not, I don't know.
And it's their view back to the reality of the effects we're planned for. Well, thank you for that.
Campbell. Yes, I hadn't intended to read the summary.
No,
So have you jumped in?
We've already done a summary,
Question?
Michael, thank you. Yes, we've read. So we've got questions.
Well, I think it might be quite useful if you could just go through like Mr. Stiles did under his 4 headings. Road vibration, rail vibration, rail noise and road noise, and essentially bring us up to speed on, I mean, your evidence and what you've read since then as to what your summarised position is. Certainly, and I guess probably it's no surprise that my evidence, good evidence from Mr. Stiles, but also obviously read the evidence. I guess in terms of vibration, both the road and rail are running with a basis in which to impose controls. Same. In terms of rail noise, once again, I'm convinced that there's sufficient evidence to justify controls, particularly in relation to the urban area component.
Question by text, can you speak up? Oh,
Okay,
lift
sorry.
your voice.
Yes, I've been told I'm quiet, but yeah. So from a rail noise perspective, I once again remain of the view that I don't believe that noise controls are warranted. And then finally, turning to the road noise, I do think and acknowledge the road modelling evidence. And I think that's been really helpful in clarifying the spatial extent of the corridors, and particularly in the urban environment. And as Mr. Stiles indicated, those spatial extents have reduced by a reasonable margin. And I remain of the view that the modelled approach is the appropriate approach to managing noise effects that the panel considers those to be effective. Based on the evidence of Mr. Stiles, I view that it would be appropriate, subject to that. Okay, thanks.
Yes, yeah, I got a response. It was positive.
Great.
Yeah. Keep doing that.
I'm deafened. Okay, starting with the last one first then. Do you hold to the view then, if the modelled approach is applied consistently, that it ought to apply to all of these state highways, regardless of the speed environment? Or do you still say that there ought to be that 70 km/h differentiation where the controls would apply above 70, but below not? My view was, I agree, concurred with Mr. Stiles, that if the noise effects were appropriate in the less than 70 km, I make the caveat that there were some provisos that Mr. Stiles provided, and he hasn't had a chance to look at the final detail in the assumptions of the model, so there may be some refinement to that, but the principle of a modelled noise below 70 km/h, I accept. That's accepted. So we can assume from that you consider the objective of managing health and amenity effects on people matters more than the potential cost implications of new or altered activities having to spend a little bit more to create that internal acoustic environment. Yes, but where I've landed is I think it's important that you minimise that corridor to the maximum extent that you need to. And I've also, as part of my evidence, also suggested that some flexibility to alterations to existing dwellings to provide a degree of reasonableness to allow people to have existing homes to undertake some minor works to their homes without having to be confronted with significant mitigation costs. Okay, that's helpful. The reverse sensitivity issue, I mean, it's both helpful and unfortunate that you've raised this issue right at the end of the hearings, because of course, and I'm talking here particularly around protecting road and rail from reverse sensitivity as opposed to protecting other infrastructure. Because of course, we started with the strategic objectives hearing where we've given an interim suggestion that there ought to be a specific objective around protecting infrastructure from reverse sensitivity. We then can trace through that objective into the transport objectives and policies. So there are very specific policies in the transport chapter around trying to manage and avoid reverse sensitivity. So we've got this marriage already between the concept of managing reverse sensitivity and the road and rail infrastructure. And in this instance, right at the end, we're getting a proposition that perhaps the road and the rail infrastructure don't need that degree of protection because it's a fanciful sort of effect to worry about. What do you say we ought to do then with those other provisions in the plan which tend to mirror that marriage, but that we're not talking about today?
Well, I guess, you know, you haven't made any formal decisions on those issues, and I guess the panel is satisfied that reverse sensitivity doesn't occur to rail and road. It's reasonable for you to note those exceptions within the various document aspects of the policies.
That's true. Yeah.
Hamish, I wonder whether, I've been thinking about this as well. We've had the transport hearings happen some time ago.
I do think, sorry, Commissioner, I do think you did raise the issue.
I wasn't on that. I didn't sit on that one.
Yes, that's exactly what, that interrupted me.
Yeah.
Exactly the point I wanted Hamish to check back on. I do recall some of those policies were debated and discussed.
Okay.
So depending on where your recommendation ends, if you can look back at the consequential issues for those previous hearings and the recommendations from the staff on those matters.
Yes, okay. No, that's helpful. So I hate to come to a view in one section of the plan that is at odds with other stated objectives in the other, but as you're right, we haven't landed on all of those issues yet. So that's quite helpful.
I suppose if I can just add,
Yeah.
there are, I wasn't involved in that hearing, but there are typically quite high level reverse sensitivity provisions. We're dealing here with a quite specific example of all. Certain effects in certain circumstances. So the fact that you form a view on this will not necessarily have implications for the broader, the highest level policies.
Well, maybe. Just trying to dig out our IE2. Unless someone put it in there.
One of the planners has referred to that. I wonder whether they could pipe up and give us a reference. Certainly, we just want to test this proposition that the high level objectives. I'm pretty sure it does deal with both of the issues on the table we have today. So could one of the planners or one of our council listening in point us to who might have dealt with that? Oh, FIE2. We can't do it this way. Christine will need to go to our minute 9. Bring up the interim guidance. Yeah, I'm at 9. Sounds like no one can recall referring to that. We have read it in this bundle of evidence. So there's an attachment to this at the bottom. Just go to that. The very last page should have IE2 on it. Yes, so can we blow that up? Share it, yes.
IE2. Oh, no, IE1.
It's IE1, sorry.
So what we've said is the benefits of infrastructure across the district are recognised while ensuring their adverse effects are well managed and reverse sensitivity effects are avoided. So given that roading and rail would fall within the general definition of infrastructure.
Yes, but so do other. So it's much broader category.
Yeah, it is. Yeah, I agree. It is.
And I suppose you need to get to the point of thinking, well, do I have a reverse sensitivity issue here or not, that I need to avoid? And
oh, no, that's exactly right. Yeah, that's exactly right. So this is the broader, and as we get more focus, so all I'm saying, or I guess I'm only just wanting to make sure that this is a fully integrated piece of output in the end. And I guess what you're saying is that if we accept your argument around that there is no need to manage reverse sensitivity in respect of rail and roading corridors, then we can deal with that in the subordinate provisions and potentially the transport chapter.
particularly in terms of this particular issue that
Yes.
here, which is this noise vibration issue, that do we need to avoid reverse sensitivity there?
Yeah.
And we would say, don't.
Yeah.
Not really an issue, but we do appreciate the need to manage as road noise, particularly the only the health and amenity.
So when you look at that strategic objective, it says while ensuring their adverse effects are well managed.
Yes.
So you see that in the gambit of the transport authorities, it's their
Well,
responsibility.
I think it's broader than that. It is, I would see the adverse effects being well managed through firstly the imposition of, well, the transport authorities using BPO, basically. That's their side, and no, we aren't dealing with the rules that impose upon them, but the Act actually has something to say about that. So, and then in the context of them using BPO, is there a need for an additional set of provisions in terms of what land uses happen alongside it and how they are developed? And where we're up to is we're saying there isn't for vibration on either road or rail, there isn't for noise on rail, but there is an argument that says, yes, you should have something in terms of noise for land uses alongside roads. And
So that
then the management is, where do you do the split in terms of the obligations?
Well, yeah, that's right.
And you're trying to find the most appropriate of a series of, not necessarily perfect, because there will be no perfect answer necessarily, but the most appropriate mix of obligations, which is, in this case, the provisions are proposing that there be an obligation on new activities coming in, and that kind of makes some sense, you get that. But then there's an issue about what do you do with the difficult category, which is the existing activities that nobody's saying we should fix the effects upon these people. But the rules, then there's debate about whether you should then allow them to do anything and leave it in their discretion as to whether they do something at a higher level or not.
Well, to some extent, though, this plan's not doing anything about wiring management or the attainment of BPO by the infrastructure operators, is it?
Correct.
No, we're sort of relying on the fact that they are currently good corporate citizens and will comply with their general obligations of law.
Correct. And I think what you can do though is say we should be imposing additional obligations on landowners adjacent on the assumption that BPO will be done. Otherwise, you're giving an out.
No, I think
Something
that's a really good
with
point.
somebody else.
That's a really good point. We should be saying that, you know, that we have, if anything, these provisions have been proposed as part of achieving the objective of managing adverse effects of infrastructure on the assumption that the other unwritten bit is that those who are creating the effects are actually achieving the best practical option. Yeah. Yeah, so the management is broader than just telling the infrastructure operators to do something.
And equally, it's broader than just telling the neighbour
Yeah.
to do something.
Yeah.
It's a mix of these two, some of which are implied and some of which are explicit.
I mean, how do you avoid reverse sensitivity effects anyway? I mean, it's, says he who wrote the words. How do you, I mean, in the terms of roads, how do you avoid them? You just don't have people live next to them.
Living anywhere near them. Yeah.
Yeah, or you have a blank line, which is at 100 meters, it's prohibited to put a sensitive activity. So you actually have or you build a wall.
Or more likely, you have a mix of provisions that mean that the likelihood of
That's not
complaints leading
avoiding.
to something else. No, but again, the fact that you're going to get complaints is probably inevitable at some level on any. Is there then something that you see as likely to be an outcome that affects the operation of the polluting activity, if we put it that way? It's unreasonable, isn't just simply mitigating the effects that they're generating. It's,
Mr. Campbell, have you come across any provisions in district plan reviews that try and, I guess, share the burden of managing this effect beyond BPO and internal controls? And I give you the example of port expansion. This is one Mr. Stiles would know about. Northport wanted to alter its noise rules because it was thinking of expanding, and it proposed rules in the district plan which said that it was allowed to produce noise up to a certain level, but if it wanted to produce noise greater than that, it had to make an offer to existing residents within a certain contour to improve their acoustic amenity. So the rule was, you can emit that noise, but only on the basis that you've made an offer to protect. And it's up to that person to refuse the offer, but ultimately the rule in the plan said you have to take some responsibility as a condition of your activity to do that. The opposite side of it was that for new users coming in, then they had to bear the burden of protecting themselves in advance. But I mean, it didn't get anywhere in the end because the court didn't go down that path. But in terms of a rule that sort of shares that burden between an infrastructure provider and those who are affected by it, have you seen any of these in this context?
Mr. Campbell said no, he hasn't.
No, I haven't. The only other question I had, and it may be unnecessary now, is I found it quite difficult to get my head around your maps, just in terms of what you were depicting, and
Can we just bring one of those up? Stephen, I think just before we get rid of the strategic objectives, these strategic objectives have been reported on in the sweep up hearing. And so there's an opportunity for any parties to think about where we landed in our interim decision stage, and give us some further evidence as part of the sweep up hearing. But just so we don't forget about that, because everything we'll be referring back to these strategic objectives when we make our other decisions. So, okay, and Christine, Mr. Campbell's evidence. Get it, her dependent. Who is it? Well, it's right at the back of the evidence. It's a series of plans.
sheet 4 might be the most helpful. Because that's got both the rail and the road corridors on it. I think I know what you're depicting, but I just want you to clarify.
Yeah, fourth down. Right at the back, there's a series of plans.
Walk up. Yeah.
Oh, sheet 4.
Did you share Mr. Campbell, what he's doing?
This being shared.
Yeah.
He won't be.
Yeah, I think you can see the key.
Yeah.
So the rail.
Perhaps if you use the mouse, is people can then see what you're indicating people out in the ether can see what you're indicating on the screen.
And speak up.
Okay. I think the idea was for the rail corridor, people see my mouse.
Yes.
So that's just showing the differentiation between the vibration control and the noise. I think the noise was 50 meters and then the vibration is slightly wider.
So that the darker blue and then the lighter blue
Correct.
over the purple.
Yeah.
So you're depicting here what the infrastructure operator's relief
Correct.
was. That's
Just simply showing you
the spatial extent of what
the relief.
Okay.
Yes. And similarly, for the road noise, for the rail noise rather, sorry, I've got it the other way around. The dark red is the 60 meters and the 100 is the vibration.
So that's rail, which you're
That's
indicating.
rail.
Yeah.
And the blues with the road.
The blue is the road, yeah. And there's a sort of a dotted line, I think there is. Is that clear?
So the dotted line shows where the boundary between the noise and vibration start. And it's much more potential on the rail corridor than the road corridor combined eyeball.
That's because the difference between the noise of vibration was 60 and 100.
Now, I get that now.
Thank you, Michael.
Sorry, Mr. Campbell. You heard the question asked to Mr. Stiles about your experience you've had of reverse sensitivity becoming a real impact on road and rail corridors. Are you able to provide us any examples?
I can't provide an example of a situation where reverse sensitivity has curtailed the operation of the rail.
That was all my questions.
Thank you.
Thank you, Michael.
Don't get cheeky.
See, be grateful.
Who are you twittering with?
Alison
Yes.
is
Oh.
giving me commentary on the volume level that we've got.
Okay.
Thank you, Alison.
So Michael, I have a couple of additionals. The first one is about, you answered a question from Kit regarding BPO approaches and plans, and he said we weren't ready.
Correct.
In terms of this issue.
Yep.
But have you ever seen a transport authority use a BPO assessment? We've heard the example of the Ellerslie noise walls, and determining their effects and what might be the most appropriate response to adverse noise levels from transport infrastructure.
At a district plan.
Yes, or been hearing or anything where you've seen BPO being used?
Not off the top of my head.
Okay, thank you. I'll ask you this question about the government's transport policy that they issue every few years. And the latest one is very much about multimodal transport future. Is that how you see that? Okay, and I asked Mr. Stiles a question about the future, and given that IPCC is saying if we go above 1.5 degrees increase in temperature, we're going to be in big trouble as a world. Part of that there's big encouragement through a number of statutes in New Zealand to get to carbon zero and 2050, 2035, there's a target. So given those statutes and that planning framework, do you think it's appropriate or reasonable to be factoring in any future thoughts about our transport fleet?
I think there's an inevitability in terms of where we're heading, in terms of our management of fleet. And I think we are transitioning away from fossil fuels and we are transitioning towards alternative forms of transportation. And so I think the inevitability there is yeah.
So there's two carbon zero act I'm thinking about. I think there's a 2050 target to be carbon zero with our transport facilities. And before that, there's a 2035 target for all electricity generation to be renewable.
Correct.
So we're talking within the bounds of 10 to 15 years. That things will have to be changed through the government's own statutory regime.
Yes, and I think you're seeing initiatives underway with vehicle subsidies in terms of EV and hybrid vehicles. So it's not going to be something that suddenly happens. It will gradually increase as technology improves, as costs go down. So I think you're going to see a gradual transition to meet that target.
So we're, in terms of making a good decision on this road, rail, noise corridor issue, do you think we should be cognizant of this future? Is this future likely in your view?
I think it's highly likely.
Yes. So it doesn't assist us if we're told we don't know, so we can't model a plan for that. Thank you. And look, one other question I have is relates to Mr. Holswich situation, where he's interested in not only seeing the noise modelling contour that goes up to the 80 or 85 metre buffer, we can establish that. He'd like to see in terms of their ancestral land, Maryland, where the modelling shows outside that 80 metre. Do you think we should have access to that in terms of making our decisions so we can think about the effects in the round?
Yes, I do. I mean, the 85 is an arbitrary point, albeit the submitter's point of view that landed on it. I think if you were looking at this as an evidence of the actual use of the model, then I think you should look at it. Whether or not you how you deal with it, that's something. But I think model taking a fixed-based approach, that would be the appropriate.
So moving on to the next, and I think the last question I have is, you made a comment in your summary, I think it's L, 1.2L, that Kiwi Rail needs to justify the noise and vibration effects from the position of any noise or vibration controls. So you've written that. You've now read rebuttal evidence from Kiwi Rail. Has any of that changed your position?
No.
They haven't provided the evidence that you'll be seeking to justify such a control.
Correct.
And the reason for that is?
Well, I think it's the nature of the where it's located and where it sort of services, what its capacity for growth is in terms of servicing port in particular, in terms of the frontage of that corridor running through there at its current, to me, there isn't sufficient evidence to justify it.
And it's that I think Mr. Stiles, that there's in the next hearing deals with port noise, that there's some predictions about capacity of this port carrying and the ability for the likelihood of receiving more rail. The evidence we've seen is that that's any substantial uplift in the rail fed by the port is quite small. So
that's my understanding. Mr. Stiles may be small point, but from my point of view, I've seen nothing that indicates it's going to be a substantial increase.
Thank you for that. Look through to the back of the evidence to see if we've got a follow-up. Yes. Oh, the Auckland Unitary Plan, my understanding when the IHP considered that there was a lack of data, no modelling like we have in this case. That's a factual difference. Correct. That's right. Yes. And no, that's everything for me. Thank you, Michael. And there's another question.
Yeah, I was just going to ask something I missed before. In terms of our higher order policy guidance here, we're not in a situation where, for example, there's a national policy statement or anything that deals with roads in the RMA sense or rail in the RMA sense.
Not that I'm aware of.
So the peak of the moment that we're looking at really is the regional policy statement in terms of our statutory obligations.
I would suggest so. I guess the national policy statement has relevance to the extent
The national policy UD.
UD, to the extent of creating well-functioning urban environments. So it's slightly different outside of the urban environments, but I think that's a relevant consideration. Considering the issues.
Here's where I'm going is that, and it comes back to this issue of the infrastructure operators, the road and rail operators having to justify what their future effects might be, as opposed to simply being able to assert there is a national policy which says you need to plan to provide for us, sort of regardless of our effects to some extent. In terms of the road and rail providers, though, and I guess what I'm getting is there's nothing which avoids a need to actually envisage what their future effects are going to be. I mean, the argument that comes through quite strongly in the Kiwi Rail submissions is that road is fantastic. There's been a huge rail is hugely important. It's economically critical. I think the word critical was used lots of times in those submissions. But is that enough? I mean, should we be satisfied that just because this is critical on the assertion of the evidence, without actually anything concrete about what its scale of use or expansion is likely to be, is that enough just to warrant putting controls in your view?
I personally think, I don't dispute that the provision of that infrastructure in most circumstances will be critical, but I do think that localized assessment is also important in terms of specific circumstances of a spatial area. And then there does need to be consistency, but not all railways are created equal and not all roads are created equal. So I do think that people sometimes, we don't use a sledgehammer to crack a walnut because of a sort of a perceived constraint issue. But I also think at the same time, it's incumbent upon the infrastructure providers to factor in in their program, their maintenance programs and their ongoing BPO obligations in terms of dealing with pressures as they come onto their network.
That's something I'm going to take up with. Thank you for that opinion.
Thank you, gentlemen. Alan.
Are other people sitting? I might wonder if we might just go sit at the table.
You're welcome to
the rest of it until the next submitter who's present here.
Ms. Bellamy is going to be coming later in the day.
Yes.
Also might be.
I think we go to Wakakatahi and Kiwi Rail next, so it might be useful for us if we can just sit at the table.
You're welcome to. Yes.
Kiwi Rail are not scheduled till 3.
Yes.
Could almost take an early. Well, it's a question of
what we've got a gift for Wakakatahi. Yes, and then we'll think about that. Okay, Waka Kotahi team, go on.
Good morning, Commissioners. You should have in front of you, hopefully, the legal submissions which we filed on Friday.
Thank you. Yes, we do.
And am I correct that you've had a chance to review those submissions?
Yes.
Excellent. Okay, I'll just briefly talk to the key points in those submissions. So firstly, as you probably gathered at this point, there is quite a high degree of alignment between Waka Kotahi and the council officers in relation to the provisions. There are three key outstanding matters. There are some relatively minor matters relating to the Transport Corridor Specific Objective 04 and some minor amendments to a couple of policies. There's also an outstanding issue in relation to the application of the rules in relation to alterations and additions. And there's also a request for the rules to apply to all zones and also add a ventilation standard and also some matters in relation to additional matters of discretion. Other than that, there is, as I say, quite a high level of agreement. Kāinga Ora is obviously still some areas of disagreement with Waka Kotahi. And I think at the crux of what I can gather from their arguments is that there's a desire for Waka Kotahi to mitigate noise on the existing state highway at source first, prior to any further controls being imposed on landowners or developers coming to the state highway, new developments. And I'll cover that later in my submissions. Section 2 of my submissions just sets out the scope of what I've covered. Section 3, I'd normally go through Waka Kotahi's statutory objectives and functions, but I'm aware that both of you will be quite familiar with those. I do want to just point out, though, at this point, I draw your attention to the government policy statement for land transport, Waka Kotahi's document, Arataki, and also Toitū Te Teo. And those three documents really do set the scene for Waka Kotahi's obligations in terms of managing well-being and improving public health in the transport sector. Sorry, can I just check that you can hear me all right? I'm just getting a little bit of feedback. All right, great, thanks.
Look, we can hear you fine. Everyone in the room can hear Christina okay? Yes, yeah, thank you. So I don't know, are you going to move on from your section 3? Because I have a question.
Sure, you're welcome to ask that question now.
So in terms of our decision-making role, how would you describe the status and relevance of those three documents you cite?
They certainly, Waka Kotahi's statutory duties obviously come from the Land Transport Management Act, but those policy documents do really set the scene for how it undertakes those functions. So they do provide a relevant context in terms of how it exercises those powers, in particular, and ensuring that the land transport network is well managed, and also just planning for the future of that network.
Do you have the LTMA handy? Because I read your submissions last evening. You cite 96(1)(a) of that Act, requiring Waka Kotahi to exhibit a sense of social and environmental responsibility. Can you actually tell me what the words in the Act are, or does your paragraph 3.2 just parrot back the words in the Act?
I'd need to double check that. I'm afraid I haven't got it on my screen at the moment.
Okay, so can you just make a note of that and come back to us?
Sure. Yeah.
Today. I could look at it myself and Kit probably can as well. I couldn't might have had it at your fingertips seeing you cited it.
Sure, no problem.
Thank you. Just carry on, Christina. Thank you.
Sure. So picking up at section 4, so in that section I outline the need for controls in relation to noise sensitive activities, establishing close to the state highway. And I set out the reasons why it's necessary to manage noise. Clearly, Waka Kotahi is relying on the World Health Organization standards and guidelines in relation to the adverse health effects associated with exposure to noise from land transport networks. I think it's important to note too at this point that Waka Kotahi manages some 11,000 kilometres worth of state highway. It's a really long linear network, so it is quite different from other noise emitting infrastructure such as ports and airports, which are more site specific. This is actually a very long linear network over thousands and thousands of kilometres. When Waka Kotahi constructs its networks or its new roads or upgrades its existing corridors, it does go to massive lengths in terms of mitigating that noise on existing land uses next to the network. The difficulty that we effectively have here is that we have very long existing network throughout the country, which passes through both urban and rural areas. And particularly in the rural areas and the peri-urban areas, there's a lot of pressure on the land adjacent to that network, because obviously that's the land which is well sited for future residential development. It's got, obviously being right next to the state highway, it has excellent transportation connections. So there's a lot of pressure throughout the network for these new land uses to establish adjacent to the network. I think there's been a lot of talk by Kāinga Ora about implementing the best practicable option, and Dr. Charles's evidence and Ms. Heppelthwaite's evidence outlines what the practical constraints of that is. In particular, there's been talk about new seal being put down, that low noise seal. Now that is sometimes used in relation to new roads, but as Dr. Charles's evidence explains, there are limitations on where that low noise seal can be used. In particular, it's not suitable for close to intersections or roundabouts. And also I think there are other limitations which he can speak to you more about in relation to the speed environment as well. There seems to be this impression that Waka Kotahi can and should respond to every new land developer that wants to come to establish adjacent to the network and establish a noise sensitive activity. And as I've mentioned, Dr. Charles and Ms. Heppelthwaite explain why it's simply not practicable. Turning to section 5 of my submissions now, as you're well aware, the modelling has finally been produced, which is great. As you probably appreciate too, it is part of a broader exercise being undertaken by Waka Kotahi throughout the country. So it has taken some time to get that exercise completed. As Dr. Charles points out in his supplementary evidence, there is some sort of verification or quality assurance that needs to be undertaken. But as you've heard from Mr. Stiles, and I think also, if I understand him correctly, Mr. Lloyd, subject to potentially some further discussions about how that modelling's been undertaken and satisfying them in those respects. Hopefully I'm not putting words in their mouth by saying I think there seems to be a general agreement that that modelling is to A, be preferred, and B, is fit for purpose, subject to those final verifications occurring. In anticipation of the modelling coming forward, Ms. Hepplethwaite's rebuttal evidence does outline some provisions, updates the provisions to refer to that modelling, the model contours rather than the set distances. So we provided that wording for you. In section 6, the key changes sought to the section 42A report provisions. I won't go through all of those. I summarised them briefly at the beginning of these submissions, and Ms. Hepplethwaite has outlined them in her evidence as well. I think one of the key issues there is probably the change to the alterations additions rule, which both the council planner and Kāinga Ora have requested in terms of placing a size limit on the alterations or additions. Sorry, hang on a minute.
Hey, how you going, Christina? Are you managing with that?
Yeah,
No, we can hear it. It's a bit of a struggle.
Yeah, I'm not. I actually don't feel that bad. It's just my voice is completely giving out, which is not ideal. Still negative on the COVID test, but I don't know. I'm going to do another one after this, I think. Sorry, so apologies. So yeah, the alterations additions rule is probably the most significant difference between the council and Waka Kotahi. There is some, quite a lot of difficulty in determining if you are going to put a size limit on the alterations and additions, what size limit that would be. Kāinga Ora and the council, I think, have both settled on a 25 square metre addition as potentially being appropriate, but Ms. Hepplethwaite has explained why there are difficulties in putting any kind of arbitrary limit on that in terms of the additional exposure which can occur when those additions are made in terms of increasing the size of habitable living areas. In terms of the Kāinga Ora submissions in section 7 of my submissions, I've probably covered most of this. I point out in the first part that Kāinga Ora's concerns really do seem to revolve around this contention that Waka Kotahi should exercise a BPO first, and the practical difficulties which are associated with that. I've also outlined again the issues with the alterations and additions rule. In terms of vibration, and I'm looking now at paragraph 7.9, there's essentially a disagreement between the experts here as to whether it warrants control or not. Dr. Charles's evidence is very clearly that he considers that for new sensitive activities within 20 metres of the state highway, those rules are warranted to control both health and amenity effects. In terms of the Auckland Unitary Plan decisions and the analysis by the independent hearing panel in relation to the noise rules for that plan, I think you've correctly pointed out that 6 or 7 years ago when those decisions were issued, Waka Kotahi wasn't in a position to have the modelling available. There has been a very significant project undertaken since that time, which has really looked at this issue in much more detail. And that has included, as you've seen from the Section 32 report attached to Ms. Hebblethwaite's evidence, a lot of work looking at what the best options are for managing that noise, plus this very extensive modelling project which has been undertaken. And the other thing I'd like to point out at this point too is that it's not unusual for these types of provisions to be included in district plans. There are examples throughout New Zealand where they have been. Auckland at that time, as I said, 6 or 7 years ago, decided not to include them. Basically, it felt that the analysis wasn't robust enough at that point in time, but things have certainly moved on in the interim. Turning now to paragraph 7.12, there is a suggestion in Kāinga Ora's evidence that our relief would potentially erode the outcomes in the MPS UD. Don't agree with that contention. The rules don't actually prevent urban development. They simply require an assessment of the potential health effects and then for mitigation to be undertaken. And I think it's also important to note that the Section 32 analysis does look at the costs of that mitigation to the landowners, and that cost is in fact very insignificant in the context of the overall development. Turning now to Section 8, in terms of Waka Kotahi's response to other submitters, in terms of the Ngāti Rāhui Hapu trustees submission, I certainly meant no offence in terms of any of the statements that I made in the legal submissions. I understand that their main concern does relate to who pays for the noise mitigation. As I noted in the legal submissions, Mr. Catchpole has contacted them and has had what I understand to be a very productive and useful discussion with representatives of the Hapu. I understand that those discussions will continue outside of this hearing, and that they have been certainly very cordial and productive to the extent they've occurred to date. Finally, Section 9, I outline the statutory framework. I'm not going to take you through those. I've included them for completeness in attachment A, but I'm aware that you're both very aware of that statutory framework, and I won't take you through it. In terms of the witnesses, I would actually propose that Dr. Charles goes first, followed by Ms. Hebblethwaite. And in terms of their evidence, you should have in front of you copies of Dr. Charles, copies from both of them of the evidence in chief. Both of them have done rebuttal statements, and also Dr. Charles's supplementary statement relating to the modelling. So
thank you, Christine. Yes, thank you for those. Before we go to questions, I'd just like to, I suppose, to the wider Kotahi team, express our thanks for getting that supplementary evidence with modelling in the door. I know, I can tell from being on the other side of preparing for evidence, it looks like worked pretty hard to get us that. And I think even if it's coming late and we haven't all had the chance to really sort of get our heads around it, getting it to us is hugely appreciated. So Alan, thank you very much to you and your team just for getting us that. It will certainly help us with our decision making and certainly brings a new level of information to us. So I want to acknowledge Waka Kotahi for the effort to bring that to us. So Pat, I'll just see whether you have any questions. No. Christina, Pat doesn't have any questions, but I have a couple, and I suppose the first one, I asked you about the three main policy documents that you referred us to in your section 3. You also refer us to the 2015 Waka Kotahi Guide for the management of effects on noise sensitive land uses near the state highway network. That's in your 4.2. You see that there? So again, my question is the status and relevance for our decision making of that guide. It's come from, I'm just interested in who wrote it, peer reviewed, requested by the courts. Is it, yeah, just to get my head around that. And again, you might need to come back to us on that, but it is referenced in your legal submissions as something that Dr. Charles has reviewed. So again, Stephen might have some more information and you could refer to him, but did you have anything more for us on that?
Yes, so the 2015 document was really the precursor to all of the work that Waka Kotahi has been doing over the past 6 years on this issue. I understand, and they'll correct me no doubt if I'm wrong, that Ms. Hebblethwaite and Dr. Charles, or at least Dr. Charles, was involved in that document, in the preparation of that document. It hasn't been tested through the court as such at all. It's simply a guidance document issued by Waka Kotahi. I mean, I guess you could almost think of it in a way as being a statement of where its thinking was at that time in 2015 in relation to this issue.
Okay, thank you for that answer. My only other question relates to your section 7.2 of your submissions. And again, you might want to take some advice on this, but I'll ask the question of you as the counsel for Waka Kotahi. So this is where you say that you refer to Ms. Hebblethwaite's evidence that it would cost at least $150 million to retrospectively manage noise exposure for approximately 50% of persons currently exposed to noise above the 64 dB. Do you see that there?
Yes.
Okay. So my question is, are you suggesting, and that's why I asked you the question about section 96(1)(a) of the LTMA, which requires Waka Kotahi to exhibit a sense of social and environmental responsibility. Are you saying to us that cost of $150 million is too high, or is it just to deal with things from an agency perspective on areas that are exhibiting currently high noise levels?
I think that's just simply a statement of, it's simply a statement of the approximate cost of managing it. That's not going to address all of the noise, as I say in that paragraph. That would be about $150 million to manage noise exposure for approximately 50% of those people affected currently. But it's not just the cost of the measures, it's the practicalities of implementing those measures, which are a massive issue for Waka Kotahi.
But do you know if there's a project or budget provision to put that, which sounds like you need to go through a BPO, how you deal with each of these areas? Is there a forward program or forward budget, or would you need to find out about that?
As far as I'm aware, there's no budget for it. I mean, I think the problem is Whakatahi's managing 11,000 kilometres. Where do you start? Do you respond to each land development which comes up, which means you've got a very higgledy-piggledy ad hoc response?
Yeah, I'll just stop you. That's not the question, sorry. That your paragraph deals with existing issues.
Yeah.
I get your point loud and clear, and it's probably your best point in 7.7 about that, you can't anticipate where these future housing developments might go. But what I want to get a sense of is, in terms of Whakatahi's overall national budget, what percentage would that $150 million be? Because you've told us that costs of up to 2% of a new build for new houses at 2% is not significant for affected landowners next to the highway. And I've seen some figures in the evidence that might be $15,000 or $20,000 additional. I'm just trying to get a perspective about the budget factors that Whakatahi has to deal with its BPO obligations for existing noise affected areas. And you'll probably have to go back and find out that percentage for me. But maybe, Alan, you could help with that. It just puts it into context.
Certainly.
Thank you. Okay, so look, that's the only other question I had. And we move to your witnesses.
Certainly, I'd now like to ask Dr. Charles to provide his evidence. My understanding is that you've pre-read his evidence. Would you like Dr. Charles to give a quick overview of where things currently sit, particularly in relation to the modelling, if that would be helpful?
Yes, I think, Stephen, if you can go through those 4 areas: road, noise, the vibration, road rail, and the noise, road rail, just like we've done with some of the other witnesses. And then certainly really appreciate your advice on the recent modelling. Thanks for getting it to us. And just outline where you're up to it as an expert, and its fit for purpose. It's not even a word, but it's utility for us putting into the district plan. So thank you, and go ahead. Certainly.
Thank you, Commissioners. So I haven't prepared a summary statement. I was told I didn't need to. I've been sitting here listening to sort of 3 hours of questions, and there's all sorts of things that I could respond to. I won't dive down everything. I'll let you ask the questions, but there's just a few high level points I will make, having heard everything that's been said. So starting off on, I'm going to answer questions on rail this afternoon alongside the KiwiRail witnesses so that they're sitting in context. And so although I've got combined statements, I'll try and separate out the road and rail, which plays to those 4 points you're making.
That's fair.
On the road noise, I think there's been a lot of talk, almost as if it's a question of best practicable option or land use controls. And I think that's slightly misleading. So we've got robust evidence of the fact of widespread adverse health effects from the existing network and for any new houses building near that network. Quarter or a fifth of the population exposed to adverse health effects, and that's the same in Europe. There's been mapping ongoing there for a couple of decades. So we know that we've got a large problem. We know that's a real problem. There is no silver bullet. So it's not a question of one party or the other party taking some action and suddenly that problem's gone. There's a significant issue that warrants a response from a technical point of view, and there's not a straightforward response. And so when I've advised Whakatahi over quite some years now, it's a broad strategy. It's a complex response that includes lots of moving parts. And the land use controls we're talking about today is one of those parts. And so it's almost, it's a bit like climate change where you can't just give up because the little bit you do doesn't solve the problem. It's a problem that warrants a response, and you've got to take these little steps. So regardless what Waka Kotahi does on its network, there's still going to be a need for these land use responses. You were just questioning, Christina, about the mitigation for properties over 64 decibels. Just highlighting there that 64, that's still a level at which adverse effects are occurring. So that 64 is just the tip of the iceberg property. So even if Waka Kotahi spent that $150 million, there's still a need for the land use controls for the new buildings coming along.
Yeah. Stephen, can I just ask you on the way through, that number relates to 50% of the worst affected adjoining landowners, and that would ordinarily be where you'd start thinking about making some impact. Would that be fair?
Yes. So we've got 500,000 people that have got more noise exposure from the state highway network than the World Health Organization recommends. Those sorts of numbers. Waka Kotahi, since it had an environmental plan, I think it was 2007. It's quite a long-standing environmental plan, and in terms of how do you start eating the elephant, it said, okay, well, we need to target our interventions at the highest exposures, and so it had a noise improvement program that was targeted at those the highest exposure. So treatment would be warranted at lower levels, but you've just got such a big problem, you've got to start somewhere, and it makes sense to start at the place where the exposure is worse. So Mr. Stiles referenced one project in Ellerslie, but there have been noise barriers erected by the State Highway Network at least going back 10 years or so. On the Southern Motorway, there's various stretches there that were put in, not in relation to a capital project, but just in relation to mitigating the existing noise. So Waka Kotahi had those measures ongoing for some time. The funding there's been gaps in the funding for those measures. I'm here as a technical expert, as I'm involved in Waka Kotahi work. I know some of the details of what's occurring there. There's currently a 5 million, or there's some relatively small amount of money. There's 3 locations where there's barriers being implemented in Auckland at the moment. They're relatively short sections. And in terms of the National Land Transport Plan that's being prepared at the moment, we're pushing hard to get more money in to address some of that 150 million that Mr. was talking about earlier. So in terms of fitting barriers, there's been work for some time. The funding's been ups and downs, but that's ongoing. But also, I do a lot of work on road surfaces and improving road surface, investigating, researching how to improve road surfaces. So that's all. Waka Kotahi's funded quite an active program of research over 5-6 years at least. And I've done work on detectors to detect the trucks with the louder engine brakes to try and sort of identify those vehicles and reduce the noise. So there's a whole range of activities that are just chipping away at this big problem, and the land use controls sort of fit within that overall picture. I'll step back now onto just in terms of where things are at on the road noise and then road vibration. So in terms of the road noise, my reading of the evidence is that there's general agreement that controls are warranted, and the differences are around the extent of controls and so forth. I don't see, for a given noise exposure, I don't see any technical reason why one location should be subject to a control and another location shouldn't be subject to a control. In his the Section 42A addendum, Mr. Lloyd's evidence, he talks about some balance about the benefit in lower speed areas, and I don't follow that logic. In those areas, there are still locations that have the same noise exposures that warrant mitigation as further away from a higher speed section of state highway. So for a given noise exposure, there's a technical basis by which a land use control is warranted. So I think that's the main thing, and that comes through in the mapping where it shows, well, this is the actual the exposure is closer to the road in the lower speed areas, but it's still the same effect on those people. In terms of there's been quite a lot of questions around electric vehicles and the future and so forth. Largely, I just reiterate what Mr. Stiles replied, that on highways, even certainly on the higher speed roads, most of the noise you're hearing is from the wheel road surface interface, and until we've got floating cars, whatever propulsion system you've got that same noise coming from the tyre wheel tyre road interface. So the model to that extent represents a future fleet that's 100% electric or hydrogen powered or whatever whatever transpires. In the lower speed areas, it used to be that as you got to lower and lower speeds, that the propulsion systems, the engines became more dominant. With modern cars, that's no longer the case. If you stand by a road and a combustion engine Corolla drives past and a Nissan Leaf drives past, you'll hear the same noise even at those lower speeds, because it's mainly coming from the tyre road interface. So again, the modelling is appropriate for both the high and low speeds for a future fleet. I think I'll wait for further questions rather than rambling further on that. I'll close off just on the vibration. So the vibration, so on the road noise, there seems to be a large agreement. On the road vibration, Mr. Stiles and Mr. Lloyd consider that controls aren't warranted. My evidence is firmly that they are warranted. So I've been involved mainly in response to complaints, looking at vibration levels around all sorts of places around the network. It's not 10 a week or anything, it's a few a year usually, or it tends to come in clumps, oddly. But the levels that you can monitor by ordinary sections of the highway will routinely exceed the guideline criteria. And it's not just if there's a pothole or if there's a defect in the surface, yes, that will do it. But it's often an underground services or some kind of discontinuity change in the sub base. And those you can, if you rebuild the network, if you dig everything up to half a meter and rebuild your entire 11,000 kilometers of state highway network, you could get rid of it. But in the existing legacy network, it's part of the network. It's an inherent part of the network, and I say routinely have vibration levels above those criteria around the network. It's very difficult with vibration. You can't predict it, which is why I've suggested there's a 20-meter area where people are required to have a closer look, and that's the sort of distance where previously Waka Kotahi would say no, just don't build that close. So it's saying if you are building pretty close to the road, then have a look at the vibration. Sorry, I said I wouldn't ramble. I will just pick up a question on you're talking about the 2015 guide. So Waka Kotahi or Transit Transit had what was called a reverse sensitivity policy, and it was contained within its planning and policy manual, Appendix 5D, and I can't remember the date of it, but it's been there for quite some time. And that reverse sensitivity, it was called a reverse sensitivity policy, and that had an exclusion zone. It was seeking close to the roads, and then an effects zone where buildings should be treated. So Waka Kotahi or Transit had been seeking land use controls and district plans for a long time on the basis of that previous policy, and then there's various controls around the country and operative plans that have come about through seeking to implement that policy. As Waka Kotahi went around various hearings seeking to implement that policy, questions got raised in the same manner as now, and so leading up to that 2015 guide, Waka Kotahi took a step back and said, well, what are all the questions coming up with our policy? And so there was myself from a technical acoustics point of view, and there was Aaron Hudson was the planner responsible. We sort of went through all the questions that had arisen and reframed what was a reverse sensitivity policy as a guide to sensitive land use near highways. I can talk in more detail about that, but
that's fine. Was that peer review? What's the position of that? Was it something just you and the planner put together?
No, trying to get publications through Waka Kotahi is a very painful process. So there's extensive internal consultation. So it was all of the Waka Kotahi planners and legal teams and so forth. And then there was an external consultation going back 7 years. I can't remember the forum, but it was circulated for comments externally. It then went through an internal approval and then a ratification to be published as a guide. So there's no external scrutiny, but there is a robust process to get it to the point of being a ratified guide. So in terms of being ratified, it represents Waka Kotahi's position, at least at that time.
Okay, thank you. Are you ready for questions?
I am, yes. Please.
I don't have many of you, Dr. Childs. Your evidence is very clear. In your primary statement, and I will only focus on roads, because I know you'll be back this afternoon for rail. Paragraph 2.6, you talk about, you said you've been involved in numerous cases throughout New Zealand where people in houses that were established near to pre-existing have then affected the operation of that. And you've given two examples, one of a situation of a house built next to a railway line, and then an example in Nelson of some subdivisions near State Highway 6 that led to a campaign for a change in the road surface. Do you know, in respect of that latter example, if the campaign was successful?
I apologise for not giving a yes, no. It is a complicated answer. So in the noise improvement programme, the 150 million that you're referring to, that section of road was included in that consideration to have the surface change. So to that extent, it was successful, although the process by which that was included was based on noise exposure, not just on the complaints. So the two factors are heading in the same direction.
So we could say that it was partly Waka Kotahi exhibiting a sense of social responsibility, partly it wanting to achieve the BPO, and potentially it being hurried along by some residents who were campaigning.
Yeah, I think it. So in terms of the, so there was I've been involved in preparing a business case for addressing or for looking at existing noise exposure, which is where that 150 million figure comes from. And that business case, complaints were considered, but the primary identification of areas that require treatment was on the basis of exposure. So okay. we know about complaints and we can't unknow about them, but in terms of prioritising and identifying sections, it's primarily on the need and the exposure. There are certainly lots of areas around the country where people are requesting lower noise road surfaces or so forth on a fairly regular basis.
You talk about at the start of that paragraph examples of cases where the operation of pre-existing roads has been affected by sensitive activities. Can you, I mean, you talked about this particular one here. Are there any others that where you can confidently say that Waka Kotahi took steps in respect of the operation or improvement of a road solely as a consequence of adjacent sensitive activities beating down their door and asking for it?
Yes, Oh, not, sorry, in terms of the sensitive activities being there, not in terms of them beating down the door. So, I mean, so last week I was reviewing Southern Motorway, Papakura to Bombay, one of the stages of the project there. There's widening and bridges or whatever of the existing corridor. There's a section of that where there's some houses that have been built in the last 5-10 years next to the pre-existing State Highway 1. Now that Waka Kotahi is in that particular location, it's taking a few meters of land. And because those houses have been built there, it's having to, Waka Kotahi is evaluating noise barriers along that area. And that's despite there being I can't remember whether it's a subdivision consent condition or a encumbrance, but that's despite those new houses having had some requirement to treat themselves. So the presence of new houses routinely causes Waka Kotahi to have to look at mitigation that would otherwise wouldn't have been required.
Thanks. Thanks. In terms of that same line of questioning, are you familiar with any examples within the New Plymouth district?
So
examples of, well, let's just use what everyone's talking about. Examples of reverse sensitivity in New Plymouth, where Waka Kotahi's had to do something to its roads as a consequence of complaints or campaigns by sensitive activities.
I don't have something off the top of my head. No. The sort of cases I was talking about just now, all of those things, the adverse health effects on people are occurring regardless of complaints. And I was listening to the legal submissions by Kaingoroa earlier, and there was an assertion somehow that people are making choices and so on and so forth. Those health effects are occurring due to the noise exposure people are living within. Whether or not they complain is completely irrelevant to the health effects that are occurring. The complaints can be an indicator, but that's not determinative of the effect. So the examples I'm talking about where Waka Kotahi knows that there are adverse health effects, it's then incumbent on it to look to mitigate those when it's undertaking its projects. And so really the notion of the issue only arising in response to complaints, I think is a bit of a fallacy, or it's a misunderstanding of what the effect is that's occurring.
No, fair point.
Thank you. Thank you, Stephen. I think that's everything from Kit. I just had a couple of questions of you, and again, thank you for your 3 statements of evidence. I think the rebuttal processes worked really well in this particular case where the experts have really had a chance to think about things and refine things down. So I think that's worked really well, and thank you for your evidence, which is clear. Where you're less clear is around this modelling and your supplementary evidence, which we got on Friday. And my question really is about, this is seems to be hot off the press. You're not across all of the input assumptions or everything about how this modelling has been derived. Would you support a discussion with Mr. Lloyd and Mr. Stiles just to work through your common understanding and give us some joint advice in a brief witness statement?
I'm certainly more than happy to talk with Mr. Stiles and Mr. Lloyd.
Yes.
I'm slightly nervous about false expectations. So I would never have pushed this modelling through for this process. The modelling should have been ready a year or year and a half ago, and so it shouldn't have been a question. It hasn't been ready, and I would not have wanted to have put this on the table now without having all the documentation tick boxes checked before putting it on the table in front of you. Given Kāinga Ora's evidence and their strong support of modelling, we've expedited it, but that does come, means the modelling is in front of you ahead of its documentation. That documentation isn't going to be resolved in the next few weeks because it's outside my control. And it's in a separate contract that's got its own issues, but it will come, but it's not going to come in a rush. What I would say is, because the outputs of the modelling have been capped at 80 metres and 50 metres, the consequence of the modelling being wrong or the modelling having an error doesn't mean extra people are going to get included, beyond which if you just use a fixed distance. So the fixed distances were an approximation. So if you went on ahead with just the fixed distances, the modelling wouldn't affect additional people. So the risk of there being any errors wouldn't have an issue on that side. So the main risk with the modelling is that within the 50 and within the 80, there's some people have been included or excluded, or perhaps should have been one way or the other. As I understand it, Waka Kotahi is happy to use the support the modelling, accepting the fact there may be some errors around the margins, but knowing the fact that it's bound by those 80 and 50. In terms of the quality assurance and so forth, in terms of the modelling, so I'm not going to be able to have a more certain outcome within a short space of time on those. So I can talk to Mr. Lloyd and Mr. Stiles about what I've got, and that doesn't include a very detailed quality plan that we had for a standalone exercise elsewhere. Yeah, but as I say, I think.
What about this plan that's been developed at Whangarei we've heard about that supports that modelling? That's further ahead. Certainly, and I'll talk about timing. Our hearings finish 26th of August. Our decisions are due end of October. You are talking about not being able to sort of firm anything up until November. And we've also heard today that things are much more advanced in Whangarei, particularly around this modelling document which has been prepared. So I know you have to confer with your client, but what's your, and this evidence has been given to us on, hey, this is better than we had, still hasn't been properly checked. You've done some spot checks, I think you said in your evidence, and it looks about right, in the right ballpark. Can you just describe what you've done with those spot checks? Have you just looked at a couple of areas, or where you got some data?
Yeah, so again, I apologise that if I was asked how many weeks ago, I'd say no, we're not in a position to put this on the table. So I apologise that in trying to come to the table with the parties, we've stepped ahead. In terms of the difference between Whangarei and here, so there's the national project, which is this big beast that we don't quite have direct control on. And in Whangarei, which was happening earlier, we knew there was a risk that we couldn't control the national work. And so there was a separate contract to pull the Whangarei out of the national work. And so there was tens of thousands of dollars, brought us a separate quality plan and methodology document, and it brought us those contours ahead of the national project. If we'd known a year ago that we were going to be in this position, potentially the same could have been done for New Plymouth. We were being told at the time that it would all come through before now, but it transpires it hasn't. We can't in the next few weeks now kind of change tack and spend an extra how many tens of thousands of dollars and do this one separately. So we're sort of stuck in an awkward halfway house.
Yeah.
As I
So,
said,
I'm not asking you for problems, Stephen. I'm
No,
asking you for
so-
solutions. We were asked a year or so ago to hold off on this because, trust us, we're doing all this work in Whangarei and we'll come to hopefully a resolution, and we've deferred this right to the last moment. And we're not, are you just saying we just have to do the best with what you've given us in your 29th of July supplementary statement, or is there anything else that could be done to verify or make us more confident that we are using a
So-
reliable data set in the
Yeah,
district plan?
So certainly in terms of the, from the noise contours to the processed outcome, then in the next few weeks, we can work through some checks on that. So I think that would be beneficial. And I can sit down with Mr. Lloyd and Mr. Stiles to discuss the methodology as far as I understand it. But beyond that, I think we are saying, here's a set of contours. We don't have that 100% certainty, but the risk of using them is relatively low because they're constrained by that 50 and 80 meters. So the upside risk of them being further away is that we've prevented that.
Okay. Would there be benefit for the council and the public in New Plymouth to know the outer extent of the modelling beyond these? And is it 85 or 80 meters? Like your plans to about 85, something that.
Yeah, sorry, I was going to clear that up. So in terms of effects, I always go off the edge of the traffic lane because that's where the noise is coming from.
Yes.
For the modeling's all based off the centre line. And so I've added 5 meters to try and approximate the edge of the traffic lane. So that's where the 80 gets to 85. If you look at the section 42A addendum, all of their maps, they've measured the 80 off the edge of the land parcel. So, between 80 off the edge of the lane, 85 off the centre line, and 80 off the land parcel, they'll all be moving around a little bit. They're all trying to achieve the same thing, but there'll be some wiggle errors between them.
So this comes back to your point that there will be time to do some GIS refinement on those sort of issues. And if we ask for that to be done in coordination with the council's GIS people, that's achievable. Because if as you're recommending, we put these model lines with the constraints of the 85 meters in the district plan, that's what Katai is asking for. So there is some time to actually do those cross checks, and we're being implored by the authors of the E-plan that any mapping changes, they want to get to them ASAP because it's a huge job for them to sort of add in. But so in terms of timing, is it a end of August type of exercise to talk with the other two noise experts, do this QA checking as best you can, and then work with the council GIS mapping people to look at how that might look in terms of their E-plan?
Yep, from my perspective and a technical perspective, yes. Obviously up to Waka Kotahi because they need to sort out their GIS people to stand behind me and so forth. Yes.
Okay. Look, I'll take submissions on that at the end, but that's our thinking. And we would prefer a document to come to us summarising where that had got to. And Hamish tied into your final reply. But we'll confirm that. So look, that's.
Can I just on the two land parcels that you asked for contours, I've sent the GIS request on those specific ones. I haven't heard back yet, but I don't see an issue.
Okay, and again, Mr. Holsworth is interested in not the constrained boundary at the 80-metre line. He's interested to see, and again, for the benefit of, I can understand why, because if they've got only 2 or 3 places they could go, they really want to know where they are going to be affected on their limited land and protect themselves in making decisions as well. So So I think that's certainly going to be useful. Yeah, Kit's got another question,
Just-
Stephen.
Just following on from this discussion with the chair about if we were to go down this path, what it might look like. There's obviously the GIS component of it, the map that would go along the top. You heard Mr. Stiles talk about a document, and I think I have it in my mind that it's potentially an appendix to the plan, which talks about the model setup and the assumptions, just so that there is, I guess, a record of how it was formulated and created. And are you familiar with the sort of document that Mr. Stiles is referring to there?
I think initially he was referring to a much more detailed quality plan for the modelling exercise in terms of very prescriptive in terms of what all the inputs outputs were for the modelling. And I don't think that would be appropriate in the plan. To some extent, the once you've got an overlay on the maps, it's just defining an area of land. And I think, yes, it'll be helpful to have a brief summary of where that came from for people looking, but in terms of the details of what the inputs were for the model, I don't think that's appropriate in to be in the plan. So the proposed rules, they apply to any parcels that are within this area that's shown on the maps.
We know that. Yeah. All right, no, thank you.
Thank you for your assistance, Stephen. We'll hear back from you with the rail head on a bit later.
Great.
10 to 1, I'm minded to have a brief break before we get to you, Kath. If we could come back at 1:30, have a brief lunch, and we'll pick up with you at that stage, if that's okay.
Yes, sir, no problem.
Yes.
Just a thought, the Kiwi Rail is set for 3 o'clock.
Yes.
Unless you're going to talk for an hour and a half. And think, wait, I think to the next party, or they've got some other video.
Look, I just need some fuel, I'm sorry.
No, I agree with that. I'm just making the point whether it's worthwhile trying to get Kiwi Rail to come in earlier.
Oh, they've already told us they can't.
Oh,
It's
okay.
through a note to me, and I've accepted their.
So presumably we change the order.
I'm not sure, Christine, whether Ms. Bellamy can come.
She was
Casey,
hoping to get in early.
Casey can come in earlier.
Bring her in.
I think it's a good idea. So we'll try and get Casey in before 3 o'clock. And then we'll adjourn until 1:30 and pick up with you, Kath, at that stage. Thank you.
Thank you.
Thank you. Thank you, everyone, and welcome back. Just been a conversation in the room about how squeaky the chairs are here. So in terms of audio, it's one of the features of this room. You might hear a bit of squeaking going on, so that's what it is. Okay, so Christina, we're back with you and your team.
Yes, we have Miss Heppleswaite now. Hopefully.
Thank you.
There she is.
Good to see you again, Kath.
Kia ora koutou, everybody. Thank you, Mr. Chair. As with Dr. Charles, I haven't prepared a summary statement, but would you like me to follow a similar pattern as the other witnesses and just comment on noise, road noise and road vibration, and then highlight any key points from the earlier sessions?
Yes, please. That would be
Okay.
helpful.
So probably just my summary statement just refers to the points. The summary statement provides details of the provisions where we've got to. Level of agreement there between myself and Mr. Campbell is reasonably good, I think, for the most part. There's just a couple of things. So in that regard, I agree with Mr. Campbell that modelling would be the ideal outcome, but I am mindful of the haste at which Dr. Charles has worked to extract the information, and that may not be as accurate as it would be should the full process had been completed. In saying that, if the modelled provisions or the modelling itself is found not to be acceptable, I still think the fixed 50 and 80 metre outcomes are a reasonable substitute, and while slightly less efficient, could still work quite comfortably. The controls, I have considered the evidence of Mr. Westney, and in terms of the extent, and there was a discussion in Mr. Westney's report and Mr. Campbell's about whether standard S1 should refer to named zones or all zones. So I proposed what I hope is a solution which would be acceptable and reflect the concerns of both parties. So that is included in my evidence. The other thing that I just like to address specifically with regard to noise is the 25 square metre exemption that Mr. Campbell has proposed, and you'll see my evidence that I don't support that. I do not consider, I mean, noise from infrastructure and other things of the like nature is not a problem that we have arrived at overnight. It's a long-term intergenerational issue. It's an issue that's going to take some time to address. And I would agree with the sentiment expressed by Dr. Charles this morning about this being one aspect of addressing the issue, and there are many other ways which are or could be progressed to solve the problem, but it's not going to happen straight away in terms of both existing dwellings, but also moving into the future. New development happens incrementally, and we'll see hopefully an incremental improvement in the health or outcomes of people who by choice or otherwise locate close to transport infrastructure. So in that regard,
just on that statement, Kath. So yes, Dr. Charles talked to us about it's not an and or situation, is it? There's an and. We need to use all of the royal we has to use all of the concepts and good planning in the toolbox, which relates to both the BPO and also where necessary and appropriate controls and district plan. Do you agree with that?
yes, I do, and I think it goes broader than that. And I heard Commissioner Littlejohn this morning mention the Building Act. There's obviously also MPSs and NESs, which are also mentioned, none of which are obviously on the table today and are outside the ambit of here, but they're just examples of other tools available.
Thank you.
Just returning to the 25 square metre and probably also the tenor of the discussions this morning, there's been a really strong focus on residential. And I do acknowledge that residential impacts are the most significant in terms of areas, because residential housing is one of the more predominant land uses, particularly in the urban environment. But there hasn't been much discussion about the impacts of the 25 square metres on non-residential uses. And in my evidence, you'll see a note there just regarding childcare as an example. The definition of noise sensitive activities obviously spreads wider than residential. So just drawing that to your attention. Vibration, I don't have a great deal to say about that, except I'm reliant on Dr. Charles's technical evidence. And in that regard, I have included provisions in my attachments 1 and 2, which are attached to my rebuttal statement. Sorry, I should have referred to that earlier rather than my summary statement. And they reflect Dr. Charles' technical view that vibration is an effect and that it needs management. And in that regard, there are provisions there proposed in red text. So I think I could probably best assist you by simply answering questions from here. I think my evidence is probably fairly concise and straightforward, but I'll leave it in your hands.
Thank you. And yes, we agree your evidence the way you've laid it out is very, very helpful. So we can go straight to questions. We'll start with Kit.
Thanks, Kat. Just two questions really. The first one, your recommended changes, and I've got your rebuttal evidence here. Your suggestion for noise S3, all zones except as provided for in 3 and 4. 3 and 4 are the specific internal acoustic insulation requirements in the commercial zones, isn't it? And the mixed use zone.
Yes, generally speaking, yes.
So the use of the phrase all zones except is meant to try and avoid any duplication that might happen by labelling some for that and others for internal. Is that the
Yes.
only,
That's correct, yes.
The other one I want to talk about and explain the reasoning a little bit more is noise P2. And this is where you have suggested changing the phrasing of it from a policy which starts allow for sound attenuation measures along the edge of state highways and railways to protect indoor and outdoor amenity. You want the language more directive to require noise sensitive activities to provide for attenuation measures. Your initial version, you took out outdoor amenity, but then you've suggested that that ought to go back in. But none of the provisions that we're talking about in terms of the noise standards there's no trigger for outdoor amenity, and there's no method or requirement to address it, is there?
That's correct, yes.
So I'm still just trying to understand the rationale for a policy which requires attenuation measures in certain locations to protect outdoor amenity when there's no methods to do that. And I think the agreement is that it's a waste of time to do it anyway.
I wouldn't agree with the last statement about a waste of time. I think there's a difference of opinion, but I do acknowledge your point that now I have changed the prefacing text to require that there is no method around outdoor. I know initially I thought, well, I appreciated that, but there was some expectation that, particularly at subdivision design, that there would be some thought given to the design of outdoor amenity. But I acknowledge your point now that now it says require, that is a little bit out of place.
I think hasn't the issue arisen because in its original conception, the policy was more directed at the state highway operator putting in place sound attenuation measures, whereas the rephrasing is now directed the purpose of the policy to the noise sensitive activities. And at least that's how I read it. Is that how you read it? The original was allow for sound attenuation measures along the edge of state highways to protect the indoor and outdoor amenity of adjoining noise sensitive activities where appropriate. That to me was a policy that was speaking to the state highways, not to the noise sensitive activities. But now it's been turned around and it's a policy that speaks to the noise sensitive activities.
I don't necessarily agree with that opinion, or I would have a different reading of that, because there are no, as we've been discussed earlier, there are no provisions within the plan which require or allow or enable the state highway operator to undertake anything. So there's no, put another way, there's no obligation within the plan. So, and I must say, when I've read that,
transport chapter, is there no permitted activity in the transportation rules to provide for acoustic fences or attenuation devices along roads?
so there's no underlying transport zone which would cater for that type of permitted activity. If I refer you to the unitary plan, there's a strategic transport corridor zone which underlies state highways and the rail network, and that has particular permitted activity rules for things like noise walls and other acoustic attenuation. But in this plan, the underlying zoning is obtained from the adjoining zoning. So if the adjoining zoning is residential, the underlying zoning is residential. And therefore the provisions, if the designation were not to be relied on, the development controls would be those which match the underlying zoning. So if it's residential next door, then you could build that. So going back to your first question, no, I didn't read policy 2 as allowing a road controlling authority to do things. I read that as allowing for setting up the structure for rules in the plan, which then required homeowners or other noise sensitive activity users to provide some type of mitigation.
Along the edge of state highways? I mean, if you read it in the context of all of the policies, isn't it policy 4? That's what these standards are dealing with. Those are the machinery that refer to policy 4, which is ensure noise sensitive activities proposing to locate within those locations are located, designed and constructed in an appropriate way to ensure health and safety effects are minimised. Isn't that the policy that we're focused on here in terms of residential or sensitive activities having to provide to protect themselves in these certain cases?
Policy 4 doesn't apply to roads. Have I misunderstood your question? Because there's nothing to prevent a homeowner or an occupant of a site putting their own noise protection along the edge of the state highway. It doesn't say it has to be inside the designation or provided by the state highway operator. Similarly, as you've pointed out, it could go the other way as well. Yeah.
We're talking across purposes.
Yeah, I hadn't read it in the way you'd suggested, I think, is my response, but it could be read that way.
Go around circles. Okay.
Sarah, could I suggest perhaps that the council staff member may have an idea, I'm not sure if it was Mr. Westno that drafted it, what their intention was when they drafted it? That may be of assistance.
Yeah. So what's the, I mean, in their original conception, what was P2 aimed at and what was P4 aimed at?
So P2 relates to state highways and railway line. Yeah. And P4 relates to lines.
Okay. So by changing P2 to now get rid of the allow for to require noise sensitive activities,
it's directly relating to the noise sensitive activity.
Yeah.
Addressing their effects rather than the noise generating activity. That does change. It becomes clearer in terms of its application with sensitive activities only.
Well, perhaps follow up for me. So how does the plan propose to manage the effects from application?
I'm just looking at that in the transportation chapter. There's a general policy which says ensure the transport network is located and designed to avoid, remedy, or appropriately mitigate effects on adjacent land while recognising the positive benefits of enabling the transport network. That's the only specific.
So that's heavily qualified, isn't it?
Policy around managing the effects of the transport network.
And there's no conditions on the designation that apply to.
Aware of the operations considerations.
Yeah.
Right. Thank you, Ken.
Right, it's on to me now. So, I have a couple of questions. I'm looking back at the RPS cap in your 1.21. And these, I think, was established, there's no national policy apart from the NPSUD that we might need to look at, but the regional policy, there is some policy. So that first statement in italics here, you see that obligation pointing to who's responsible for achieving that requirement? Is it the council? Is it landowners? Is it the noise generator?
Sorry, I just missed which paragraph number in my primary evidence you're referring to.
This is your rebuttal evidence. It's
Oh, rebuttal evidence.
121. So looking at that regional policy, whose obligation is it to meet that regional policy? That's IEF policy 2.
Sorry, Sue, I'm just having trouble locating the right to document 121. Persons undertaking, sorry, you're talking about the RPS infrastructure policy 2?
Oh, yes. Who's that obligation on?
People undertaking or parties undertaking activities within the ambit of the regional policy statement and the underlying planning documents.
It's the people doing new developments, they have the responsibility as you read it.
I would, so you're talking about will be avoided or mitigated, that aspect?
Yes.
There's definitely, obviously, in the first line, it talks about the adverse effects of subdivision use and development on the, paraphrase here, network utilities.
Yes.
Then the parties undertaking the subdivision use and development would be having the effect on the utility, and that those effects need to be avoided or mitigated. So yes, I would take that as being the effects on the parties who are undertaking the subdivision or development.
Yes, that's helpful because that does then flow through into what's being recommended in the district plan. So I just was trying to just double check that nexus between the RPS and what's being proposed.
Yes, I think the other thing which is I'm mindful of this morning is the discussion on reverse sensitivity, and that is a recognised adverse effect. So it would be captured by the adverse effects of, I don't think it needs a specific reference, it's just part of the broader concept of adverse effects.
Right. So just in that same paragraph, Kat, we've got UFD 23 new, which we've now named IE1 in the interim guidance. Is that how you understand it?
Thank you for bringing that to my attention this morning. I hadn't realised it had been both renumbered and also had the addition, I think, of in reverse sensitivity added to it from the screen version this morning.
So that's evolved through our interim directions into IE1. That's right, isn't it?
Sorry, so your question again?
Sorry, that UFD 23 new, now interim directions version is now IE1.
I believe so, sir, yes.
Okay, and when we looked at that this morning, Mr. Allen, any thoughts on that moving forward to guide where Kotahi really wants to be with this objectives policy rules regime?
As with the infrastructure policy 2 on the RPS, adverse effects would include reverse sensitivity. And I noted Commissioner Littlejohn's concern this morning about avoiding reverse sensitivity might be aspirational. My words, not his, obviously. It may be difficult to achieve in every circumstance. Avoid is a very high bar. So it is something that it triggered me to think about further evidence for the wrap-up hearing. And the evidence is obviously due on Friday. So I will be having a closer look at that.
Thank you. And the other part of that strategic objective relates to an obligation on the transport authorities too, doesn't it?
Yes, it does. Yep, effects must be well managed.
While ensuring that adverse effects are well managed.
Correct.
Now, where in the further below that strategic objectives, where does that currently occur in the objective policies regime?
we have established that the designations don't require it. I think we've established that there are no specific rules in the plan which require that. I will just bear with me one moment. Mr. Westney did just refer to the transport chapter, which I am fairly familiar with. I can't think of anything immediately that comes to mind, Sue, but it's a rather long and complicated document with hearings that have spread over some months now. So if to give an answer, I would need some time to go and actually have a look at that.
So we might really just be left with section 16, the general obligation to avoid unreasonable noise, which is the technique that has to be relied on. Is that's where things are?
Certainly that's the primary directive. This morning, Ms. Sheard gave the LTMA description, and I believe she's going to give some more commentary on that. I am moderately familiar with some of Waka Kotahi's operational policy, and acknowledging that that has an internal and some external process to deal with. It's particularly its sustainability strategy. It has a very specific requirement, and it's in the it's called our Sustainability Action Plan, Toitu Te Ao. And one of the requirements, which I am happy to share, is on page 9, and it's under the long-term outcomes to 2050, and it's under the heading Improving Public Health. It's one of 4 big challenges, and the first bullet point is reducing harmful land transport related air and noise pollution, and the 2050 outcome is no harm from land transport and air and noise emissions. So I'm happy to either, or probably both, either share that on screen now and also provide a reference to that document. That is a non-RMA directive, I'm very clear on that, but it does give you indications of the public statements and directives that Waka Kotahi is looking to operate under.
I think that would be useful to just do a wee supplementary statement to us about that, and I might be able to roll up into the questions I've asked about the 150 million project and where that's up to with business case and where that fits into the overall Waka Kotahi land transport budget, which I think, Christina, you're going to put together in consultation with the team. So just add that reference, because I'm looking at the policy direction that flows from that UIE 1. And I think even if we did want to develop through the policy and the plan, Hamish, is there any scope to take that any further?
I need to check
on that.
Yeah, need to go back to the transport submission.
Okay. Look, I think if you are going to look at this for the sweep up hearing, just have a good think about all these issues we're talking about and how that strategic objective is framed.
Yes, sir.
Would be useful. Thank you. I just did have a couple of questions about your markup. And Kit's dealt with the first one about the noise P2, and we've had a good discussion about that. But could we look at page 12 at the bottom of your attachment 2 amendments, if modelling available, and that is in your rebuttal evidence?
Yes, sir.
So, Kath, I'm looking at it's on the left-hand column, number 2, where you're looking at a standard for noise sensitivity activities around vibration levels. See that there?
Yes.
And there's a standard there, 0.3 millimeters a second, BW-95. So that standard, who does that? Is that done by an architect, or does that need a vibration expert to look at that standard? What's the practice around those vibration standards, if you know?
I suggest, sir, with respect that Dr. Charles might be best placed to answer that. I know for sure it's not an architect, but I'm not sure of the correct technical term for the professional who will complete that.
Yes, so Stephen, if you're still there, I know from my own experience trying to find vibration experts to help in other cases is difficult. It does quite often sort of end up in the noise consultant's general court. So who does that assessment, vibration assessment? What sort of expertise?
Yeah, so you're right that it often does fall in the acoustician's field of expertise. So some the Resource Management Act says noise includes vibration. The two are interlinked. It's waves traveling in different medium. Some acoustic consultants tend to have quite a narrow focus just on noise, whereas the discipline includes vibration. So it tends to be a subset of the acousticians who would undertake the vibration assessment. Certainly in terms of the measurement, it's an acoustician's task. There's then an interplay between structural engineer, acoustician and architect in terms of how that works through the building design. So there's a team effort required.
Yeah. Is it it's a model? Do you plug information into a model? Does it use geology and geotechnical information and rock types?
So the vibration level, the existing vibration level in the ground is measurable. So that's a measurement. My early career, we're doing large buildings and you'd have to measure the vibration down the bottom of a borehole where the pile would be, but for most times you'd be measuring on the surface, pad foundations, so forth. There are empirical relationships for how the vibration translates from the ground to the different floors of the building. If you can rely on empirical relationships and that gives you the answer, that's fine. If you've got a complex structure, then it's structural engineering, finite element modeling to look at the response of the building. So there's a kind of there's not a one size fits all approach to the question, but it will usually start with a measurement and then it will be some kind of an analysis, either look up empirical or complex modeling.
Okay, so it is quite complex, isn't it?
Vibration compared to noise issue, vibration is very complex. Yes, yeah.
Yes.
And so that's in terms of the road vibration, it's only the smaller area closer to the road, whereas the noise you're dealing with over a larger area. But in that small area close to the road, if you're trying to do development in that area that's potentially affected by vibration, then yep, it could be complex. Some of the time you'll just measure the vibration levels and it will just fall out, and then there's no complexity. But if you find there is that exposure, then it's not a straightforward process. Sorry,
okay.
Not answering your question, but that's not a reason not to address the adverse effect.
I think you have. It's just an added issue with the vibration. It's not an easy task, and if you're setting a standard like this, in my mind, it's got to be something that's practical as well. So that goes to our decision making. Yes.
So the practical control for vibration is don't build in that area. That's the easy one. Don't have to worry about. And that's what Waka Kotahi used to seek in its reverse sensitivity policy. And in this, to enable the good urban design and build up close to the road, there's a cost and a complexity to building up close to the road. And this, it's not, you wouldn't do it if there wasn't some other reason to do it. But yeah. So.
Yeah. All right. So, Kath, I've got the same question on your ventilation proposal, that standard there, which is even longer and even more complicated. Who does that? Is that a heating engineer or a ventilation specialist? Or?
Yeah, usually a mechanical engineer, and occasionally I've had the odd architect who is endeavours to be competent in this area as well.
Thank you for that. And look, I did have, I think in your primary statement of evidence, you had an appendix, which was your section 32, your general section 32 analysis. That
Yes, sir.
Followed through thinking about this sort of as you say, it's an ongoing generational New Zealand-based issues. So I think that exercise here was pretty useful. I just need to go back and find it in your initial statement. I was particularly interested in your appendix 3 of this, which is the attachment 3 building cost assessment, Acoustic Engineering Services Limited.
Yes.
So this is June 2020. So I presume 2 years old. So the costs that are outlined here likely have increased with construction costs index going up. Is that right?
I would expect total build cost, yes, inflation's running at what, 5 to 8%, depending on which report you read. So yes, sir, I would have expected, particularly in the last 12 months.
Yes. And I just wanted to ask you a question about table 1.1. So this is where there's some costs in there that, depending on what you're doing and what type of building, it could range up to 2%. $16,000, you see that there for detached residential units up to $15,000.
Yes, sir, I see the table. I wasn't responsible for either procuring or briefing or reviewing this report, so I'm not sure how helpful I'm going to be.
So this is coming in your evidence, though, isn't it?
It's a supporting attachment that's been prepared by the Acoustic Engineering Services. So they were retained by Waka Kotahi to prepare the study, and I have relied on their findings of their study to support the Section 32 analysis. I can't really comment on the methodology or such like.
No, I wasn't asking you to comment on that.
Okay.
I was asking you to confirm the numbers that we're dealing in that order plus inflation. Is that the way you?
Yes.
Today's construction costs.
Yes, I would think they'll definitely need to be adjusted for inflation, if that's the question.
Yes.
Yes,
Yes,
for
it
sure.
is. And
Yeah.
is your reading as a planner, when you rely on the 2% maximum, is that the cost per unit that would be on top of a normal build to attenuate the noise to the right standard that I suppose attenuates the noise coming from the state highway? That's the way we read it?
Yes.
Okay. So that is quite a significant cost, isn't it, for a build?
In regards to 1 to 2% of the cost, do you think that's significant from?
No, I'm just asking you that amount.
Oh, there's no question there's an increase in cost, yes.
Yes. And I think we heard from Christina saying it wasn't significant when she briefed us in her summary of her legal statement. So where would you put it in terms of the cost? Is it somewhere between not significant and significant?
Probably on the less than a significant scale. My experience of building projects is most of them allow a contingency of a minimum of 10 and sometimes 15% to allow for change in build costs during the project life. So within that scope, 1 to 2% for contingency is not a massive amount. You can easily have a significant change in costs of 1 to 2% during construction. So if you look at it on an overall construction basis, I would expect 1 to 2% would easily fall within a contingency cost.
But overall, if you're budgeting for this, contingency would be on top of that, wouldn't it?
Yes, it should be, yes.
Yeah. Okay.
But I'm using that as an example to say that usually you'd allow 10 to 15% contingency to allow for unforeseen things. So that's quite a chunk of your building project costs for flexibility.
Kath, this wouldn't be unforeseen.
No, this would be known early on in the process. Yeah, this would be known at resource consent stage. Yeah.
So are you saying to us that it's within the boundary of a normal contingency, therefore it's insignificant?
No, I have explained myself poorly. I will think of a better way to describe that. Build costs are quite variable. I think that is my point, and that is why you allow a contingency. And in the scope of that flexibility you would expect, I don't think 1 or 2% is a significant cost. It is an extra cost. I completely accept that, but I don't think in the range that you're looking at for building, it is a significant cost.
Okay, thank you. Thank you very much. That's all the questions I have. Anything else? So Christine, I think that finishes your case.
Yes, that's right, sir. Thank you.
Yes, and I wonder, just coming back to us on the information that I was seeking about the relationship between Waka Kotahi's policy for noise mitigation for those high noise areas and business cases, and if it's budgeted for or not, and also the percentage within the overall budget. You've got that clear in terms of what you need to come back on?
Yes, sir, I do.
Yeah, okay, so we'll just leave that to you. I think if you could file that with by the end of the week with Christine, who's our administrator, we'll just receive that as supplementary information.
Thank you, sir.
Right, have we heard from Casey?
No, she hasn't emailed back, and we have put a call through to her as well.
Okay, so she's expecting, does she know that TUL are going to be at 3 p.m. and she's probably expecting
Yes, and then
to
we
be
have,
after that?
we have asked her to come in before 3 p.m.
Okay. Think, take a break. Wait for TV Rail and see when Casey ends up. Casey's only got a reasonably.
There is just one thing I was, Hamish, you were one of the original authors of the first noise report.
I was, yep.
I'm just still scratching my head around this policy, sorry. In that report, you addressed Waka Kotahi's submission where it effectively sought the same changes it's still seeking, but you rejected that and said, we're sticking with the way we drafted it. And now you've effectively got, well, you've changed your mind, presumably. What other evidence have you heard in the meantime to change your mind, though?
That was Ms. Hippowaite's evidence around the policy being clearer in terms of its purpose.
Okay.
Just got a note from Ms. Bellamy that she's on her way. So let's just take a break and we'll wait for Casey to come along. And we'll convene back when she's available. Let's just be certain. Let's reconvene at 2:30. One online knows when to come back. Okay. Yes. Ms. Bellamy, welcome. Thank you for coming down a bit earlier.
Yeah.
I've actually got to get on a plane, not too late, so this suits me up with that.
Well, limited times.
Yeah.
And then how do we live with it?
Right. So, look, we've got your statement of evidence that we read. So just really start questions of you. So yeah, perhaps just summarise the main points and then we can ask questions.
Sure. So Te Kotahi has submitted on in opposition to noise S3 and S4. The effects standards in relation to the zone specific and area specific noise insulation standards. And we were seeking clarification on whether there were instances where this multi-purpose zone. The evidence iterates that, in my view, the reasonably anticipated future uses of land in the multi-purpose zone and Māori land and treaty settlement land should, that the reasonably anticipated future uses of that land should be considered as part of the existing environment due to circumstances beyond their control when we haven't always been able to use and develop and protect their lands in accordance with their aspirations. And so, yes, we seek that, yeah, we support that the installation standards do not apply.
That's the main point, isn't it? That supports right here in the Keith's statement. So tell me the reason why that land hasn't necessarily been available to use for that to do with treaty land being returned and treaty settlements, or a combination of different lands coming into the Marapurpose zone?
I think it is a combination of a number of those factors. Like TRTR was at iwi settled in 2016, and so I think that obviously there were time and more ability to use and develop lands and aspirations. But in terms of these lands, the particular lands along Ngāti Rāhiri, yeah, I think it's a combination of reasons.
No money. I think my understanding from other hearings is there are serious aspirations to develop new Marae, for example, housing.
Absolutely,
Yeah.
They have the flexibility to be able to, do the activities that, whānau, we want to see on their lands, develop them. How they wish to.
What if the plan does put controls on land just to good evidence that it's really to keep people from their effects from highway noise and rail noise? Do you think it's important that the landowners involved know where these noise contours are, because they've just recently been modelled? Irrespective of what rules, would you like to have information on where the noise sensitive areas are?
Yes, yeah, absolutely. I think that's the main thing, is what we'd like to see. It's where are the main areas that are going to be most impacted by the noise.
Yes, and if that was the case and you had a block of land that allows choices to, like, let's talk about Kamarua housing, for example, so away from the noise areas, you at least have the knowledge to plan. I think Keith's asked to see perhaps some of that noise modelling in terms of blocks here.
Yes, definitely would be useful to develop what.
Yeah, the information resource. Did you?
No, I understand the issue, and it's quite a gnarly one. The one thing I just wanted to check though is in paragraph 12 of your evidence, you suggested that you supported the recommendations which rejected the Waka Kotahi and Kiwi Rail submissions, but my understanding from Mr. Wisney's fourth addendum was that he considered the multi-purpose zone should be added to the effect standard, and I'm just wondering whether you pulled down the right report.
I think I missed that. Yeah, because there was the new addendum afterwards. I think I
You got the updated one, which was updated at the date of the last hearing, wasn't it? Yeah.
Okay.
All right. So have you had a look at that one?
Yes, I've had a brief.
Oh,
Yeah,
good.
yeah, I was like, oh.
Because I mean, his recommendation is on the face of it quite sensible, that if there are going to be situations where activities where people might be exposed to existing noise and that's not good for them, then something needs to be done to protect them. And I guess the issue is, and I quite rightly acknowledge the complaint here that, well, that's just us getting our land back and looking to develop it, having to suffer from an effect that's been caused over time adjacent to it. That's not of our making. So why should we now have to bear the cost of protecting ourselves from it? Which, as I said, is a bit of a gnarly issue for us to get our head around in the context of district plan, really.
Yes, and I mean, I totally see the, need to protect, sensitive activities from that noise, but in the context of Māori land and multi-purpose zone, I think those noise producing activities are almost the sensitive uses of Māori land and multi-purpose land almost or should be viewed as part of that existing environmental already. So when they were developing those noise producing activities, it would have been
Well, that's right. And I think we haven't had actually a lot of, virtually any, certainly not in the hearing, we haven't had any owners of land adjacent to the state highways other than Tangi Whenua come to us and say, this is unreasonable. I'm looking to develop my property now on, out on the highway, and now I've got to spend an extra 15,000 on extra jib and double glazing and stuff. That's not fair. These guys have been making this noise forever. Why should I now have to do something about it? We haven't had any people like that come along, which doesn't mean they probably don't exist, or perhaps they didn't read the summary of submissions carefully. Who knows? But to some extent, it's a similar. It's not the same issue. It's a similar issue in a way. It's about at what point in time do activities that have apparently been going on for a long time have to take steps with their neighbours to try and address those long-term effects. Yeah. Are you aware, though, that provisions wouldn't require you to insulate? You could potentially apply for a consent not to and put extenuating circumstances up and potentially bring in some other mitigation that might be able to help.
I think ultimately, like, I can't speak for all Tangi Whenua, but it's likely that they will insulate. They're not going to want to be affected by noise, but it's having that choice, and the ability to develop their lands and how they'd like to without being
Without being told what to do. Yeah. Yeah. No, it's a fair point. I get it. Okay. Thanks, Casey. Yeah, I didn't have any other questions.
And look, I suppose the other observation, which you might comment on, is Waka Kotahi, they are responsible for the transport networks for all New Zealanders. So it's all about behaviours driving on roads, and it's the use of the road rather than the road itself that that's been growing exponentially in terms of number of cars. So it is a difficult public agency providing a public service. It has effects. The effects are caused by all of us. Yes, so it's an interesting issue, and one that we've heard today is being tested out all over the country. And it looks like we're making some good progress on good planning concepts. So we'll take it on board. Casey, thank you for coming along and providing the evidence, and we'll let you carry on with your day.
Thank you very much. And I think I'm not sure if I'll yeah, thank you.
I think we are going to have another break, waiting for the New Zealand Rail team, so we won't play quietly until 3 o'clock, I suppose. Alison, can you hear us okay?
Yes,
We
sir.
We can hear you.
Perfect. Yes, thank you, sir. So you can hear us
Thank
okay?
you. Yes, you're loud and clear.
Thank
How are we
you.
going here?
Thank you for
Yeah.
projecting, sir. I appreciate it.
You're welcome.
I
So
do.
over to you, Alison.
Thank you,
Yes.
sir. And we've got you till 4:15, is that right? Hard stop?
Yeah, look, I've got to be out of here by 4:20, but we do need to have just a quick reply from Hamish and Nigel. But the ball's really in our court to be efficient. So, yeah.
Yeah, understood. So you don't want me to read my entire legal submissions word by word? That's what I'm
No.
picking up here, sir?
No,
Thank you.
no, thank you.
Yeah, understand. And look, can I just say as well, thanks very much for the indulgence of the virtual hearing. I know it's a real pain for everyone and always much better for us all to be there, but grateful with COVID and sick kids and everything else. So we're grateful, sir.
Yeah, yeah, and look, just my comments this morning, it's frustrating on both sides. And I have, you have asked to come on by Zoom, and I've said it's fine with the circumstances. And almost every hearing we've had since our last sort of lockdown, we've had a mixture of in person and in the room. But yeah, so that's all fine. We'll carry on.
Thank you, sir. So you've got legal submissions and the evidence and rebuttal, et cetera, from the team. Just a few sort of summary comments from me, and I've been listening to most of the day. I should also introduce Ms. Rapley here, who's been listening throughout the entire day. Just some summary comments from me, and then a very, very brief page flip, and then happy to take questions, and then we'll hand over to questions from the experts, sir.
Thank you.
And just a few points from me first. I think I was chided earlier in the day from overuse of the phrase critical in my legal submissions. Thank you, Mr. Allen, who's probably counted the number of times I've used critical. I'll text him about that later. But sir, the reality is that the rail infrastructure and corridor, not only nationally, but through this region, is critical infrastructure. And one of the reasons we've sought to really reinforce through legal submissions, and then also in particular the rebuttal of Mr. Whale, who you'll hear from in a minute or two, is to really remind, if we needed to, the panel here of the critical importance of this rail infrastructure. It's an investment by New Zealanders over, well, decades, into this infrastructure through the region. And it would be irresponsible and inappropriate for Kiwi Rail to not look to protect and defend this infrastructure that New Zealanders have invested in over decades. The corridor is critical to New Zealand's past and to its future. And you'll hear from some of the witnesses in a minute, including Dr. Childs, around how the future of rail is so critically and excitingly important to New Zealand. This isn't a sales pitch for rail, sir. It's the reality of how the investment that New Zealanders, regions, and Kiwi Rail and the government have made in this corridor really does need to be able to be protected so that it can be used and well into the future. This corridor has been in the region since the 1800s. It was built in the late 1800s. So I'll talk in a little bit about who brings who to the nuisance and how best we plan for that. And in a minute as well, talk about the Auckland Airport experience, just because it's been raised early in the day. And I know there's a range of experience and understanding about that. that matter. But this is infrastructure that has been in place for a really long time, long before I would suggest many of the sensitive users have developed along the corridor. It's also been in the plans for a long time. Administrator, everyone, we can hear you. So I've just seen a chat up. Are there some folks who can't hear?
Gary Whale messaged, sorry, it was to run, that he couldn't hear, but I just replied and asked him, can you hear now?
Yes, so Gary's online as well. We can hear you perfectly well in our room here, Alison.
Okay. Can we just do a slight, just a little technical sidebar? Gary, can you not hear us? No. Might have to dial in and log back in again, perhaps.
No, Gary can't hear. I will work with him on technical issues.
Okay, thanks, Michelle.
All good.
And if we need to move folks around a little bit, sir, we can do that.
Sure, yep.
So the rail infrastructure has also been recognized in those higher order documents, and that was some of the good conversation a little bit earlier in the day. Of course, I think earlier that IE1 was put up on screen, benefits of infrastructure across the district being recognized. So that's something that's emerged out of the good work this panel has done over the last few months. Also as well, sir, in the officers recommended amendments for the transport section, the overview there, confirming the transport network, which includes railway, is a quote essential physical resource in the region. And Tran 04 states the existing and future transport network is not compromised by incompatible activities which may result in reverse sensitivity effects and or conflict. Again, then higher order provision 2, and this was some of the discussion earlier in the day with my friend Mr. Allen around the RPS and policy 2, which ensures that any adverse effects of subdivision use and development which would reduce the safe and efficient operation of network utilities and other regionally significant infrastructure are avoided or mitigated. Activities that may have reverse sensitivity effects on the safe and efficient operation of regionally significant infrastructure should locate in areas where that infrastructure will not be affected. So my submissions serve very clearly and appropriately the region and districts' current and proposed higher order documents recognize this significant infrastructure and the need to manage carefully the interface between it and sensitive activities. Also, sir, noting again, and this is something that emerged out of the discussion earlier in the day around the extent to which existing transport providers such as KiwiRail should be, what should they be doing to manage the interface between sensitive activities. I think the starting point with respect is the rail infrastructure is a lawfully established activity. Again, that designation that has been in the plan for a very long time, an infrastructure that has been located in the district for many, many decades. Of course, if and when KiwiRail, for example, as any other large infrastructure provider would seek to, for example, alter its designation through an NOR or look to, as we've seen a recent example in the Auckland region, the Wiri to Key Park project, which seeks to third main a bit of the line between Wiri and Key Park, unsurprisingly. That's where KiwiRail, in bringing a new nuisance to the existing community, looks to and does provide appropriate mitigation. And I think that's a good segue into the very briefly a discussion around the Auckland Airport example, which my friend also raised and has raised many times in the past as I think a proxy for what we're trying to talk about in plan reviews. Sir, I'm very closely involved in the Auckland Airport example. Despite my youthful visage, sir, I've been working on those designations since about 2005 as a young child. And certainly in relation to the second runway extension that went through and was approved by the Environment Court a couple of years ago. Now, when we look at the designation there, firstly, I think I would just note, if it's not obvious, airports and airport planning and forecasting are wildly different to railway forecast planning. That point aside, though, when Auckland Airport looked to affect the designation in the 90s, and I think that's what Mr. Allen was speaking about, the mayoral forum with Barry Curtis and those other leading lights. At that point, when the designation was sought by Auckland Airport, bringing nuisance to an existing community, provisions of the designation were drafted to ensure that Auckland Airport offered a mitigation package to homes that were existing at the time that new nuisance was coming to the community. But equally at that time, rules very clearly put into the designation and then the Manukau plan and ultimately rolled over into the unitary plan, the development of new activities sensitive to aircraft noise, e.g. houses essentially, in the high noise area are prohibited. So that was the very clear and cogent planning and legal response, well understood in my submission, sir, around what existing infrastructure providers need to do, where they need to look to mitigate or offer mitigation to existing homes. And again, here in this region, where the line has existed since the 1800s, I would submit beyond what clearly is KiwiRail's legal obligations to practice BPO. What we're looking at here, sir, is ensuring that when new sensitive activities are coming to the existing nuisance, that we set up a plan that enables and ensures that interface to work well. And on that, sir, my submission is what KiwiRail is proposing here in this plan is light touch planning. The proposal isn't prohibited housing next to the rail corridor. What KiwiRail has sought to do is to set up provisions which would enable and allow housing sensitive activities to locate near the corridor, acknowledging Dr. Child's evidence around that, but ensuring that there are provisions in place, permitted activity standards to encourage insulation and for developers to undertake that work to put in good homes there. As was just mentioned with the previous submitter, it's an RD activity to not comply with those permitted activity standards. Turning then briefly to the planning provisions that we have proposed here and some of the discussion and debate today around the concept of reverse sensitivity. There's been a lot of discussion on that earlier today. Again, as I've said, some of those higher order policies appropriately, in my view, refer to and acknowledge the need to plan around reverse sensitivity effects. And again, as this panel will well know, the concept of reverse sensitivity is around that susceptibility of tension, where tension may occur. It's not with respect waiting for the braying mob to come forward with concerns. So again, as I've said, the proposal here, carefully thought through by KiwiRail, is a light touch one. It's not, for example, the Auckland Airport approach, where actually you would prohibit sensitive activities near the corridor. That choice discussion that my friend Mr. Allen was having earlier in the day with you, I would query the ability for example, Kaingoa tenants, for example, to have that level of choice, but leaving that point aside, the provisions as proposed by KiwiRail do enable a level of choice for developers and homeowners. They may choose to not insulate, and as Commissioner Littlejohn said a minute ago to the previous submitter, could in fact choose to seek an RD consent and not, because they're not complying with the permitted activity standards. So there's a choice in that regard there. But I suppose taking a big step back and lifting our gaze, the fact that we have Kāinga Ora so deeply involved in these provisions suggests that there's a level of a sophisticated large-scale developer who's looking at these provisions carefully. And in my submission, I think it's a very good outcome for the district and region for a large developer such as Kāinga Ora to think about the interface effects on new residents that they're looking to bring next to the freight corridor in New Plymouth. The ultimate submission here from me in all of this is in this planning moment where we are looking to draft and design a plan that will be enduring for the next 10 to 15 years. We need to lift our gaze and we need to think about what this district needs and needs from the developers of this plan now. It is, in my submission, not appropriate to look simply, for example, at what is happening on the line today, this afternoon when we go out on site today. In fact, what we're doing in a plan review such as this is looking beyond today and looking to 10 or 15 years in the future. The houses that are going to come should be built to be here for a really long time. The rail corridor also is not going anywhere and will be here for a long time. In my submission, we have a duty, a planning and important duty to the district here to ensure that that interface is workable and that we're thinking ahead to ensure that folks who are moving into bringing that new sensitive activity next to the rail corridor are mitigated from noise and vibration effects such that the rail corridor and the rail operator who has been in this district for a very, very, very long time can continue to lawfully operate that corridor. And I think that's a discussion and appropriately an acknowledgement of sort of a two-way street here. Again, a lot of the discussion earlier today is what are the rail or the transport agencies doing? What are they doing around BPO and the like? Dr. Charles can speak to that, as can Ms. Gridlington Hancock. But also in my submission suggests there's a corollary obligation and duty on developers looking to build next to the rail corridor to ensure that those new sensitive uses are mitigated as best they can to ensure the interface between the activities is managed well. So, sir, those are my very brief summary points. Happy to take questions on that or equally through the legal submissions, which we'll take as read, but happy to dive into those as well.
Yes, thank you, Alison. We'll see if Kit has any questions on your submissions.
Thank you, Ms. Young. Just a couple, 411 written submissions, where we're getting into the reverse sensitivity effect issue. I put a question mark in the margin. I mean, that's not uncommon when I read legal submissions these days, but I just was a bit confused as to the second part of the second sentence, where you say that the fact the railway line has not been shut goes to the very heart of reverse sensitivity as a concept and effect under the RMA. And I didn't understand it. And I just wanted to know what you were getting at there.
Thank you, sir. A lot of question mark in the margins. Look, firstly, I think it's two parts to it. A frustration with respect to the suggestion that emerges often in the Kāinga Ora observations or evidence or submissions, clarified slightly by my friend earlier today, that, where are the complaints that have ever shut a rail line? We hear that a lot from Kāinga Ora. Have you ever seen complaints that have shut a rail line? Now, my submission that whether or not a line has ever been shut goes to the heart of reverse sensitivity as a concept, in that reverse sensitivity is around the susceptibility of a lawfully established activity to the possibility of constraints. That's what I mean, sir, by going to the heart of the concept of reverse sensitivity. It is not such a blunt concept, legal concept that is, a constraint needs to be something firstly, that the effects need to be so significant that we need to start doing something about it. And secondly, that the outcome of effects and therefore corollary complaints are such that something really bad happens to the lawful infrastructure provider. That was the point I was seeking to make, sir.
So it's your submission that it doesn't matter if the operator actually is constrained or has to modify its lawful activity for there to be a reverse sensitivity event. You say it's enough that a situation is created where they might have to do that for there to be a reverse sensitivity effect.
Yes, sir. And again, because it's late in the day and my friend, Mr. Allen, noted that, or acknowledged that his own submissions didn't mention any legal cases and mine do. Tasty Products in Auckland Council High Court decision where the court confirmed reverse sensitivity, this is paragraph 60, sir, is the legal vulnerability of an established activity to a complaint from a new land use. It arises when an established land use is causing adverse environmental impacts on nearby land, and the new benign activity is proposed for the land. The sensitivity is this: if the new use is permitted, the established use may be required to restrict its operations or mitigate its effects so as to not adversely affect the new activity. I mean, as I see reverse sensitivity, sir, and through the case law and as it's developed thoughtfully through a range of planning provisions, it's that forward planning tool we have the luxury of doing through processes such as this. We're looking ahead and we're not the ambulance at the bottom of the cliff that waits for the braying crowd or waits for 10, 20, 30, 70 complaints. I mean, what's the right number before people are really disturbed or really upset? That's when we act. That's not what reverse sensitivity is about in my submission. It's about ensuring that we're planning exactly in processes such as these. And as I would submit precisely as the region and district are looking to do here through those higher order documents to acknowledge that these conflicts can arise. And the more houses you put next to a lawfully establishing activity, which does generate effects it cannot internalize, the more we should ensure that we're planning for that.
I mean, that last example of yours, I guess, is the crux of the matter, because most of the reverse sensitivity cases that I'm aware of, and you can correct me if there are others, have really been about ensuring that when we are planning land uses, we don't put sensitive things together. And so the concept about avoiding reverse sensitivity is very much a spatial sort of approach to putting the noisy, smelly, dusty things over there and the things that need lots of quiet and sleep over there. And by and large, when you're planning with a blank canvas, you can do that relatively effectively. In a situation like this, where we've actually had two uses living together for 100 years, and yet they both seem to be living quite well, in that they're both still there. I mean, we've got areas of the city where the railway line passes quite close to suburbs that have existed for a long time. How do we properly apply this concept in a situation like that, where you've already got two potentially inconsistent activities living together? Do you say that the duty to now focus on reverse sensitivity arises because one of those activities wants to increase in scale, and it just happens to be in this instance that it's a sensitive one?
Absolutely. Sir, I think it can't possibly be the right planning answer to say, well, we haven't done anything up to now, so we're not going to bother doing anything going forward. We have this opportunity through a plan review now. I mean, otherwise, what are we all doing here? Why don't we do any of this, really? We have the opportunity now, I mean, to better manage the interface between conflicting activities. And I would respectfully submit that the construct of reverse sensitivity becomes more important, challenging, and carefully thought through, where we're, it's becoming very rare to have these sort of blank sheets of paper, as you said, sir, where we can sort of decide. I mean, maybe that's where the government is hoping for us all to go in the future, where we take years to decide where all things beautifully go and it's going to work out perfectly. That's not the world we all live in now, where we do have a growing, vibrant, awesome district. We have a railway corridor that New Zealanders have invested in since 1885. And we want both of these things to thrive and succeed in this district and in this region. So how do we make that work? In my respectful submission, sir, it would be entirely inappropriate and irresponsible to say, well, look, folks who have lived next to the corridor since, I don't know, the 60s, too bad. And in any case, folks moving in, say, to a new Kaingora development, well, they can learn to live with the rail as well. I don't think that is good and responsible planning with respect, sir.
I guess the trouble, I mean, I accept that we're here to create an optimal outcome for competing use of resources amongst a range of different activities. We've got to look at it through a lens, though, and the lens is section 32. And this is, I guess, where the debate you would have heard this morning, and I think it's the case that Kaingora are effectively putting, to say that, yes, we hear all of that, but where's the beef? You know, the rail, there's 2 trains in a blue moon, and they're not actually that noisy. So what's the problem now? And I guess that's where we've got to work our way through that, because your proposition is that this is your important infrastructure. I don't think there's no one's disputing that. And because of that, now is a good time to put some provisions in place. Whereas the other side of the case being put is that, yes, but there's no need to put those provisions in place because there's no issue at the moment. But how do we reconcile that? Do we take a theoretical point and say we should plan regardless of there being any evidence of effect? Or do we need a threshold of there being at least an issue that we need to adjust the plan to deal with? I guess it comes to your closing sentence in paragraph 5.4, where you effectively submit there's sufficient evidence before the panel to justify the controls proposed. So I guess I'd like you to summarise what that evidence is. Is it evidence that rail is just important per se, and therefore we ought to do something about it, or is there some other evidence?
Thank you, sir. Where's the beef? Exactly. I would say that is exactly the question. Why are we so challenged by this? Firstly, I think you do have evidence. It's more than just a rail deal. It's actually, you do have evidence of the effects of rail noise and vibration. That's Dr. Childs' evidence, and he can speak that to.
But that's generic, though, isn't it? It's not New Plymouth specific, is it? Dr. Childs is trains are noisy generally, but without any specific evidence of how noisy they are in New Plymouth. Is that right?
That's right, and you can talk to him as well about modelling and sort of that broader work in the proposed corridor we're seeking and the buffer we're seeking. But you do have evidence, and even that is sort of trains are noisy, trains make people's houses shake. It is quite critical evidence, I would submit. Trains do generate effects that that go to people's health and amenity such that they will be disturbed, can complain, are not happy living there, and query whether we should be putting folks there. But you do have evidence of the effects of trains on people and on sensitive uses such as dwellings. You also have evidence of the corridor in New Plymouth, and this is Mr. Wales' evidence in particular that we called in rebuttal of the need to ensure that the corridor is protected so that the corridor, we can ensure it can continue to deliver this critical service for the region. So you have that evidence as well. And then what you have as well is evidence that says the provisions that we're seeking still enable housing, still enable sensitive uses to go right up next to the corridor, if that's what developers propose to do. No constraints on, outdoor spaces and all the rest of it, as you might see in other, interface cases. No prohibited controls and the like. So you do see also, right?
Yeah, well, I mean, I was interested because that's presumably what you've just described there, this light touch approach. And I was going to ask you, because the evidence we've had from Mr. Stiles is that to address vibration might require quite significant base isolation and engineering works with several zeros attached to it. And I was going to ask you, is that a light touch in your view?
So I think,
is it a light touch to require a single house being potentially added on to adjacent to the railway line to have to completely rebuild itself on its foundations to be able to stay there?
So a couple of things out of that. Firstly, Dr. Charles can speak to you to Mr. Stiles' several zeros construct. But I think that precisely goes to probably rounding out your original question, what's the beef? My suggestion, what the beef is around cost. It's around, including through today, and it's sort of hidden a little bit in the evidence, for example, of Kaingora, certainly in the original 42A report, an acknowledgement that there is this, there can be effects that arise as a result of use of the rail corridor on folks who live next door to it. So where the challenge really comes to, doesn't it, is around what is the cost on developers. Now, again, Dr. Charles' evidence is around costs. He would say that certainly around vibration, some of the work there can be complex and costly. In relation to noise insulation work, certainly all the acousticians on this particular topic are familiar with those costs. And in my submission, they are not in that order at all. But in fact, I would submit for the benefit that arises for homeowners and for residents and occupiers and tenants in those spaces, those are appropriate levels of cost. Further, and this final point there, the submission here in relation to opposing these provisions comes from Kaingora, a sophisticated, large, corporatized developer. And I would submit, sir, that there would be a challenge and a suggestion that a developer such as that, for example, in looking to redevelop, noting again the QRL provisions are for new or alts, not existing houses, that there'd also be, I think, a question around the level of concern about materiality of costs for the benefit in ensuring these houses are mitigated from these important noise effects.
All right, thank you for that.
Thank you, Alison. I have no further questions, and I'd just like to say thanks to you and the Rapley for the cases. I'm particularly interested in the Parawa Road one in Hawke's Bay because I've got a property adjoining that. decision. So reflecting back on Mr. Cowper ran that for the Blueberry Farm and the airport back in the day. So thank you for that. And I've really made a note about the Tasty Foods case, which seems to be sort of on point and will be very helpful in terms of taste law. So thank you both for your efforts here. Much appreciated. Should we get on to the witnesses?
Yes, please. Thank you. And also, just while I've got 2 seconds, can I also just for the record record our thanks to Julie, who's been a really great help for managing so much of this process. She's been really accessible and helpful. So I just wanted to record our thanks to her. So look, if I can call Mr. Whale next, hopefully he can hear us by now. Gary, you there? Brilliant.
He's coming on. Okay.
There we go. Am I unmuted?
You are, we can hear you.
Yes. Thank you, Gary. Just, you've got a short statement of rebuttal, which we've read. So you have 1 or 2 highlights for you you'd like to just emphasise, and then we'll get into questioning.
Thank you. Sorry about the technical issues. I'm working off my phone here at the moment, so sorry about that, but I can hear you. So hopefully you can hear me.
Yes, you're loud and clear.
Fantastic. So look, I'm Gary Whale, Group Manager, Market Strategies within KiwiRail. And look, I guess my submission is around the fact that the freight task in this particular area and that this line is actually strategically important to KiwiRail. We are a networked business, and this line does play a key role in that network. The government has over recent years, has announced some $8 billion of investment into rail. So we're exceptionally grateful for that, and we're receiving effectively a rail renaissance in that regard. A number of policy initiatives and projects that I'm involved in are around carbon emission reductions and mode share shift, and making rail more and more profitable and actually getting the value out of rail that the government has invested over some 150 plus years. Tourism is alive and well, and rail cruising is another area that we've been looking at and investing in, and it's fantastic to see cruise ships coming back, and hopefully we can get some cruise rail transport up to port, connecting with Port of Taranaki, and allowing people to experience what is a really unique experience of seeing the country, particularly the Taranaki, on rail. So look, I think that whilst you could look at the activity today as being somewhat modest from the rail activity that's occurring, we are absolutely, the government has invested widely in rail. It is a key infrastructure. They're looking to invest more. They're looking for us to grow. We're wanting to connect more with the port, more with the community, and get those nasty trucks off the road and more freight on rail, and more experiences for tourism and people on rail as well. So, to say that, this particular line is at the sunset of its future, I would totally disagree with that. We see there's huge future for this line, as there are for other railway lines in the rest of the rail network in New Zealand. And I'll leave it there and open for questions. Thank you.
Thank you, Gary. And I'll just hand over to Kit to see whether he's got some questions.
Oh, Gary, I appreciate your evidence. Very helpful, actually. I just wanted you to, and I know it's going to be a bit difficult because you're not. I just wanted to confirm paragraph 2.2. You talked about the Stratford to the Okahukura line being mothballed. Where do we, is that, if I go to your maps on the back of your evidence, is that the line that's got the 6 in the grey box next to it?
That's the one. That's from Stratford all to Taumarunui, yep.
Up to Taumarunui, okay. And when you say mothballed, what does that mean? It's just they put barriers at either end and don't maintain it anymore?
We do maintain it, so yes to barriers. So there's no active trains going up and down there other than any particular work train activity to keep the line. So we've still got the obligation to ensure that, bridges are safe, that tunnels are clear, that drainage is working. So our teams will still be spending some money, some effort up and down that line just to keep it safe. But there is no active work being done to say, right, we're gonna run a freight train in anger on the line.
Yeah, I remember when I was a young lad growing up in New Plymouth, it used to be one of the treats. My grandma would take me on the train up to Taumarunui. We used to go up there for the day, and I think it was my first experience of scones. But you go. So and any of those, you go to those little towns, you go to Taumarunui or Whangamomina, in the old taverns there, they got wonderful archive photographs of how those lines were hewn out of the landscape, just the incredible amount of work that went into building them to open up the country through there. But it's quite incredible. I mean, the history of the development of railway through the North Island is very much the history of the first major explorers through the, colonial European explorers through the region.
Absolutely.
I was very interested in your Appendix 2, looking at the commodity tonnes over the last 3 years. It's very interesting just to see how the markets and commodities change. So again, very helpful evidence, but I didn't have any particular questions. Or actually just one. In terms of this issue of reverse sensitivity that you've heard the planners and the lawyers and everyone in the room sort of talk about, have you got any sort of real life examples of where you've come across instances around New Zealand where KiwiRail has had to do things it wouldn't otherwise want to do with its network as a consequence of complaints from sensitive activities, lifestylers coming too close to it, things like that?
No, not outside my area of expertise. I'm certainly not an engineer from that perspective. I know we've done lots over the years around railway crossings and level crossings and soundproofing, etc. But no, I was not in my area of expertise. Sorry.
Okay. All right. No, thanks for that. Yep.
Thank you, Gary. I just have one. Well, firstly, I live in Napier, so I'm on the east coast, North Island. I'm very familiar with the closing and then opening again of parts of the Napier to Gisborne railway line, which was closed for a while, but with the volumes that are coming out of Wairau on logs, it's back open again, and there's freight rumbling again down there. So just really confirming that these lines wax and wane with demand, don't they?
They certainly do, and depending on it's also it's not so much the flavour of the month or what's going on, but the economics of things change. Forests have different ages, as you know, so so they'll become due for harvest, and the forest owners will be looking for an economic way to move them to the port. So there are potentially that life again will come on these lines. I take the SOL line, the one we were just referring to. That debate I was very much involved in the closing of that line and drafting the papers for my sins. But at the same token, you get a change of government, and the question of resilience and having an alternative line around that corridor comes back up again, and the appetite for reinvesting in those lines. So you never can tell, I guess, in terms of rail is seen as a strategic asset for the Crown, and that's why it procured it back, and therefore you are a bit at the whim of government policy as to where things will go, and particularly like I talk about sustainability, carbon emissions, trucks off the road. Who's to say what the government might do with the price of carbon and emissions, and try and get more freight off road and onto rail, which I believe is where it should be. I'm a little biased though.
Yes, Gary, I don't know whether you heard when I asked the questions about future government policy around climate change responses, the Carbon Zero Act and targets for 2035 and 2050. In your experience, I I think you've already said to us that rail could have a big future in our future transport network, different to what it is today, but keeping that option open seems to be your evidence for the future, because we'll need that resilience and different options. Is that really what you're telling us?
100%. That's exactly what I'm saying. The government in the carbon emissions reduction plan, the Climate Change Commission, sorry, has set out that target of a 3 to 4% mode share shift. If I put that into quantums, that's effectively we move 18 million tonnes of freight, and that 3 to 4% mode share shift would be another 6 million tonnes of freight. So it's another third of our business. So, you know, we're getting back to the good old days then in terms of the volume of freight that would be actually on rail. So it can play a significant role, and you know, that is thousands of trucks off the road and thousands of tonnes, hundreds of thousands of tonnes of carbon emission reductions, if that's the case.
Yes. And one last question. I noted your commercial roles in your introduction since 2009. Just talk to me about the Port of New Plymouth. I was going to say the Port of Tauranga, but Port of New Plymouth. It is the only sizable port on the west coast of New Zealand, from my geography. Is that how you see it as well?
Port Taranaki, I think, is the one you're after.
Port Taranaki, yes. I was going to say Tauranga, but yeah, Port Taranaki.
Pretty much as you come down that coast, I guess it's into Whanganui as well, and Castle Cliff, which has tended to be more of a bulk operator, and then down on the west coast of the South Island into Westport. And there's certainly been over the years talk of Westport, particularly moving coal shipments. Bit rough water, but down that part. But yes, primarily they're the only big or biggish ports on the west coast.
Yes. And have you, in your commercial realm, come across this coastal shipping concepts that are part of the future transport possibilities? Yes. Are you aware of any of that work?
Yes, in terms of the. Sorry.
Yes, you go ahead.
So the Move Logistics operation potentially from Taranaki through to Nelson as an example. Yes. You know, that's one that's live and well. That's just come out of, in a way, that's in my view, that's really the government also promoting to hedge some extra bets as well between coastal shipping, rail and road. It's kind of put a bob each way in each of those modes. But I would purport that, you know, the government has by far invested, as I said, nearly $8 billion in rail and creating a new, we're getting 2 brand new ferries, inter-islander ferries. We're getting 2 new ports at terminals at Wellington and Picton. We've invested hugely in the Kaikoura rebuild on that main section of line. And, you know, millions of dollars being invested in new locomotives and wagons for us in infrastructure. So to me, you know, the government is clearly put its money where its mouth is, and is investing in keeping freight on rail, or bringing more and more product off road and onto rail. So, you know, why would it have made those big investments if it didn't want that?
Right. Thank you, Gary. That's all the questions we have. I appreciate your IT problems. It's normally me on the end of an iPhone trying to dial in somewhere, but you've come across very well and answered those questions expertly. So thank you for that. Alison, we're going to move on. Who's the next witness?
Thank you, sir. Ms. Gridlington Hancock should be on the line. KiwiRail planner.
Yes.
Good afternoon, Commissioners. I'm Michelle Gridlington Hancock. I'm appearing for you as a planner for KiwiRail. I'll be pretty brief, really. I mean, the main points I'd really like to make is that my position remains strongly that the interface between urban development and national infrastructure needs to be carefully and proactively managed. I've noted the commentary by the council planner who considers that, there's no real issue. So, what's the need for provisions? Definitely don't agree with that. The proposed plan is, it doesn't just consider today, it doesn't consider tomorrow, it actually has to think about a horizon that's 15 years out, and fully understand that there is a level of uncertainty with that. But as planners, that is the type of thing that we should be thinking about. I've been listening in for most of the day, have heard the commentary from Kāingoa, and some of the questions around reverse sensitivity. So have noted some of those along the way, but happy to take questions.
Thank you, Michelle. We'll start with Kit, see whether he has any questions.
Yeah, thanks, Michelle. Just run through your evidence, a couple of things I've noted in the margin. I was interested, 3.2 of your rebuttal statement. I'll start there because that's first on the top. You talked about some complaints from users of trains who didn't like the fact that bells had been put there to warn them when trains were coming. What do you know if anything became of that? Were the bells removed?
No, they weren't. They weren't removed. Though there was 4 pedestrian crossings put in place as a result of the cycleway. That complaint actually arose as they were testing the bells to make sure that they were working appropriately, and unfortunately woke up a gentleman from his nap. They haven't been removed because, and it's a safety reason, in that the lights and the bells are, or the bells primarily are for those who are visually impaired. And so that's the only way that a visually impaired person may know that a train is coming.
Okay. So nothing came of the complaints. Are you aware of any other examples where complaints have led to KiwiRail having to change the frequency of trains or mothball a line or anything like that because it became too sensitive to neighbours?
Nothing quite so substantial as mothballing an entire line, but we have had maintenance works up in Newmarket, where we received several complaints about the noise and vibration, and as a result we had to change our schedule of works to make sure so that the hours were closer to regular business hours rather than working all night. We've also got a yard located within an industrial area where we've had to remove activities within the site as far as possible from noise sensitive activities. We're having to limit some of those activities strictly to business hours while that site is being redeveloped, and we're actually looking at an encapsulation system as part of that, because that particular activity is generating a large number of complaints.
Okay, all right. Oh, that's helpful. Appendix B to your rebuttal statement, in the first bullet point of the costs column, and I think that the reason I was drawn to this was that rebuttal. Ms. Arthur Young in paragraph 5.6 cited this as the source for a submission that noise levels typically adds up to 2% to construction cost of a dwelling. So I chased that along, saw the reference to you, saw the costs aspect of it, but I see there that you have referred to Ms. Hepplethwaite's section 32 assessment, which was a document attached to that I think was done for Waka Kotahi. Is that are we talking about the same thing?
Yes, we are.
Yeah, and that assessment was undertaken by a consultancy that looked at various building projects and how they had to deal with road noise. So I'm just interested to know whether there have been any similar sorts of assessments undertaken by KiwiRail in terms of acoustic assessment for rail noise.
We are currently working on it, but there's nothing that I've got to be able to provide to you today.
Okay, so we would need to rely on that. We'd need to be confident that the outcomes of the work that Waka Kotahi undertook is comparable to what might otherwise be required for someone to protect themselves from a rail noise issue.
Dr. Charles is best placed to answer that question for you.
All right, okay. Okay. Sorry, what's the supplementary statement?
Yes.
Yeah, sorry, I have them all together in the one document. No, that's all I had. Thank you.
Thank you, Michelle. I think, were you listening when I was asking about the RPS policy, Ms. Hepplethwaite, and also the strategic directions, IE2, Michelle, did you follow that discussion?
I did. I had a little bit of difficulty hearing, but
Yes.
I did understand that there were some questions on that.
Yes. Do you know, we did pull up IE2 in our minute number 9 on the screen. Did you follow that discussion with Mr. Allen?
Yes, I did.
Yeah. So any thoughts about that strategic objective as it sits currently? And you would have heard me sort of really asking about the policy flow down from there. Where did that leak? Where did the effective management of effects off the transport corridor flow through into this district plan? Other than in the strategic objective.
The only other place would be the NPSUD or the regional policy statement would be the two places. Unfortunately, there's no NPS for infrastructure right now.
And there's nothing in the district plan objectives and policies particularly relevant to that obligation for transport authorities to well manage their infrastructure in terms of effects?
No.
No, I think we've raised that with Hamish, and that's sort of a live issue for us, I suppose. It needs to head somewhere or wouldn't be there perhaps. So thank you. Look, my last question, Michelle, it's really it flagged my thoughts when I was reading Alison and Ms. Rackley's legal submissions about some of these documents and where they sit in our decision making. Like, I think we have the I think it's called the National Rail Strategy. Finally, that document was feeding into the GPS, the government policy statement on land transport 2021, and also refers us to the Ngāmotu New Plymouth City Centre strategy, which only got completed very recently. So it's just a place of those government